Yes.
Mayor, please, Lordship, item number 11, can you come up tomorrow, man? My senior today has some.
At the request of the learned counsel, appearing for the petitioner, list the matter tomorrow.
Tomorrow, can I
Tomorrow.
May it please the Lordship, I seek your permission to go through the records of item number 12, my lords.
Okay.
Item number 37. Engaged counsel R. Sharma, out of session, kindly.
At the request of the
Timing
learned
for today.
counsel, appearing for the appellant, list the matter again on
28 April.
28 April. Have you informed the other side?
I'm appearing on behalf of RB for record.
Okay.
Respondent number.
Okay.
Obliged.
Yes.
Mention in item number 38 and 39. My senior output is other party consent here, my lord. Kindly this matter may be listed for April, my lord.
At the request of the learned counsel for the appellant, 38 and 39.
38, 39.
List this matter again on the 4th of April.
May I please,
Yes.
Lordship, I beg to mention item number 9, Your
Please.
Lordship. With the consent of the other side, the matter may be passed over for the day, Your Lordship.
You are appearing for?
Respondent number 2.
At the request of the learned counsel, appearing for the respondent number 2 with the consent of the counsels for the petitioner, list this matter again on
Kindly after 3 weeks.
27th of April?
Yes.
27th of April.
Interim, Your Lordship.
Huh?
We are on interim.
Item 9,
Yes, Your Lordship.
interim order continues.
May it please your lordship, I beg to mention item number 4, lordship. 4. With the consent from the other side, your lordship, matter may be adjourned for the day.
At the request of the learned counsel for the petitioner. Why it is 2014 matter fixed for today?
My lord, we have to take certain instruction from the client.
From 2014 to 2026.
Not any other day, my lord, short date.
On 7th of April, it will be part hard koi reason ki WPC mulakat aise se. Let the matter reach, we'll see. Ekhon to heri hoy, WPC hoy.
May please, Lordship.
Part hard koi
Malad-
release koi din. Huh?
I beg to mention item number 17. Up to-
17.
17, my lord.
Huh.
Up to date CD was called for in this case. I'm on interim, my lord. Both.
The CD, the learned APP has submitted that the CD is awaited. List again on
22nd of April.
22nd of April.
Interim order, my lord.
Interim continues.
Hello.
This motion be item 1.
My lord, in this case, my lord, STF case, connected case, or are fixed on 7th of April, my lord.
Learned counsel for the petitioner has submitted that a matter arising out of the same FIR is listed on
7th April, 20.
7th April, being
14
BA number.
BA 812/26. Out of 4, one of this number.
List this matter along with
BA
BA number.
812. I'm obliged, my lord.
Item 2.
My
Huh.
lord, the second bail application, my lord, earlier rejected by my lordship. Cause diary may be called for, my lord, he is behind the bar for 43 days as of now. And mandatory period will over on 13th of April. So, my lord, on 8th of April, my lord, if lordship pleases to.
Call for the case diary 8th of April.
Highly obliged.
Wait, this is your lordship. Lordship, this is a regular bail lordship on the strength of NBW. He was arrested lordship. In charge sheet, he has been shown an absconder lordship. Allegation is lordship, preparation for committing dacoity. 3 person was arrested from the spot lordship. He was named although in the FIR lordship, but lordship, the rejection order kindly come to lordship page 28 lordship. Otherwise, 87 days today lordship without progress in the trial lordship is in jail lordship. 2 person already were released on bail lordship. They are appearing lordship. Now there.
When were you arrested?
Lordship arrested on lordship 29/12 lordship 2025 lordship. Today 87 days.
Paragraph, Lordship, page 28, the last paragraph also.
Huh?
It is further revealed that the accused Saddam Ali has never appeared before this court during the trial and remained absconded during the investigation.
Hmm.
That is the ground for rejection, Lordship.
Now the case is appearing at the, case is pending at the appearing stage.
So now, Lordship,
Circuit
this is
has
the,
been filed. Scan copy will be required. Lord.
Lordship, it is not a travel, Lordship, it's a exclusively travel by the session court, Lordship, until unless the appearance of the other accused are completed, Lordship, the trial cannot be progressed, Lordship. How long this petitioner will be remaining in jail was, for indefinite period, Lordship?
Where is your name in the FIR?
FIR, Lordship, accused number 5, Lordship. Page
No.
22, Lordship.
25(1)(a).
What has been alleged upon you?
Only, Lordship, in the FIR, Lordship. One, that is on page 20, Lordship. Rubul Hussain disclosed this accused person, Mohibur Ali and Saddam of one of another person were associated, but they are not arrested from the spot, Lordship. 3 persons are arrested from the spot, Lordship.
They have
Page
managed
20,
to escape at the time of the incident. Lord. And arms act is there, Lord. otherwise.
Arms is not recovered from this petitioner, Lordship. Nothing has recovered, Lordship. He was not arrested.
And 21 page Lordship, preparing for dacoity.
That
and
is the,
Attempting to murder police personnel on duty by arms.
the person who was snapped at that time, Lordship.
Allegations are serious, Lord.
Since, Lordship, other person are, Lordship, allowed to go on bail, Lordship, this reflected
Call
on.
for the scan copy of the TCR. Fifth again on, when? 7th?
Lordship.
7th of April,
Can it be 6, Lordship?
6th of April. Yes, madam.
My pleasure. So in this case, Lordship, on last occasion, tag this matter with the earlier disposed matter, my.
That CD part.
Yes,
You were shown arrested, is it?
yes, my lord.
CD খানে
Earlier-
আছে নেকি ইয়াৰ লগত?
It's your fault.
ইখন TCR?
It's your tag.
There's an office now. It office.
2612 of 2025 লগত আছিল। আচ্ছা, they are searching for it. মেইলত আহিছিলে। মেইলটো নাচাই কিয়? Okay. After some time, they're looking for the TCR in the old record. After some time.
May it please your lordship. Charged commercial NDPS case, lordship.
Yeah.
So in this case, lordship, we are not produced within the time, lordship, 24 hours.
Where is it?
Caesar list will show, lordship. Caesar list will page number 19. Your date and time, lordship, 28/7/2025 at 1 AM, lordship, in the morning. Lordship. And he was produced 129, lordship.
Just a minute.
Forwarding is the lordship. Forwarding in page number 15, lordship. Lordship. And similar case already.
Just a minute. Twenty-eighth of July at 1 o'clock, you were arrested in the morning.
In the morning, 1 AM, as per Caesar list, lordship.
Morning,
In the morning, but you was.
midnight.
After that day, lordship, on 29th. That is after 24 hours, lordship. Because if we calculate the time from 1 AM to night 1 AM, it will be 24 hours. If you presume that the accused person has been produced on 29 at 10 AM,
Where is that? His production, where is it?
Production is lordship case number 15. Time is not there.
Huh? Where is his product, this thing, forwarding?
Forwarding in case number 15, Lord.
20?
15, 1-5.
1-5. 29-7. Yes, sir, what do you say?
Regarding.
28-7-2025.
Lord.
He is arrested at midnight,
Midnight,
just when 28 is starting.
my lord. And
29,
Petition 29, my lord.
his position 29.
But I may be allowed to check the, my lord, arrest memo and all this, my lord. Can it till Monday, my lord?
Monday?
In arrest memo, lordship,
Can we deny him the opportunity to go through the TCR if it is here? Should we deny it?
after some time, lordship, because my parents is old age and they are suffering from illness, lordship.
What illness? What is the illness?
Lordship, I have not annexed because
Then,
they are very old
Then?
age, lordship. Maybe after some time, lordship. Because
What
my
are his
conduct rights
judgments?
has been violated, lordship. In similar case, your lordship already granted.
what
bail.
are his judgments which I attest? Huh? 28. Production is usually in the afternoon. Is it? In the morning also? Usually in the afternoon.
That I'll go through, my lord. What is the technical part?
When?
Monday, my lord.
Monday.
Tomorrow,
But
lordship.
he is praying with folded hands. What to do?
Then tomorrow.
Tomorrow? Tomorrow, at the request of the learned PP. Oh, tomorrow we are not there in the second half.
One day it will not hamper him, my lord.
Monday.
Monday.
Tomorrow we may not be there. Okay, Monday.
Problem.
Yes, Palak, can we be taken after some time? I was going through the records, Palak.
Oh, you are going through the records?
Yes, Palak. They may be permitted to go through the records again.
Ah, please, I said yes. You mentioned in the morning.
Yes, sir.
I said yes.
Yes.
Oh, it was not noted. Okay, did you?
Not kindly pass over the matter for time being. For item 14, kindly pass over the matter, my lord.
CD not received, sir. CD is not received.
He did not receive.
What is the FIR?
FIR in page number 8, your lord.
We'll have to await the CD. Take it after some time.
If it is possible, my time being or.
Timing.
What should I pass over for the time being?
TCR pale here. TCR is here.
Yes, we'll go through.
After some time.
16.
My lord, my senior is engaged in another court. Kindly
Yes,
pass
very
this
noticeable.
offer for
Huh?
some time.
Yes, very not the thing.
I mean, it's CD nine. POCSO is there, CD is not available.
But then the informant is some police officer. So therefore, that notice to informant goes. Is it not? The CD will reveal.
CD is not.
Informant's interest will be protected by the CD. And who are the children, we do not know. After some time, let us see now. Yeah? Mato. Manu ahi pai na ki koribo?
For addition, item 4.
এইটো তেওঁ ৰাতিপুৱা টাইম খুজিছিলে নহয় ন এইটো পাৰ্ট আছে মই ৰিলিজ কৰি দিম
My lord, kindly pass over the matter.
জাষ্ট এ মিনিট জাষ্ট এ মিনিট Who appears for the bank? You.
Yes.
You would represent the Punjab National Bank also? Huh?
Yes, your lordship.
You will represent the Punjab National Bank
Yes.
also? Pleadings are complete in this matter.
Your lordship, we are yet to file our affidavit.
Why? Affidavit in opposition filed by respondent number 5 is already there. Who was 5? Punjab National Bank. No, UBI. UBI had done the entire proceedings. UBI has filed the affidavit. Why do you need more time? We'll admit the petition,
Okay, your lordship.
fix it for hearing. Is it?
Yes, your lordship.
The required amended cost title has been filed by the petitioners. Heard the parties, admit the petition, list again on 23rd of April in the hearing column. Yes.
5 and 6.
May it please your lordship,
Ah,
I'm praying for some accommodation. The council, Mr. S. Biswas, he's on the way. Let it be taken up after some time. Obliged.
7. 7.
Please, your lordship.
yes.
So in this case, the petitioner is appearing in person. I was appointed as an amicus by this honorable court. They are not there. Matter pertains to a
I call Mr. Kosi. Mr. Kosi.
So in this case, the petitioner had filed a complaint,
Ah,
a defamation complaint matter. So that complaint was dismissed by the court on a trial court after examining the complainant and the inquiry witness. So in my respectful submission, there are two issues which your lordship will examine. First is whether even if a prima facie case is made out from the statement of the complainant, can the magistrate conduct a roving inquiry, compare the statement with the complaint to see if there are omissions and exaggerations to dismiss the complaint?
so the dismissal at that stage was not called for.
Yes, ma'am.
Okay,
The
and-
second issue is, my lord, the learned magistrate has taken suo moto cognizance of the fact that the case is covered by the exception 9 to section 499, which is a defense to the offense of defamation. Now, the other issue which I'll also examine is whether the stage of cognizance or summoning, the court can rely on the exceptions to see if the case is covered by the exceptions, or that is something,
It will require some hearing. It cannot be
Fine.
done
my lord, will require
in
some-
this routine manner. We'll have it fixed for hearing on 5th of May.
Fine.
Yes, madam, 5th of May. Huh?
5th May.
We'll admit it, fix it in the hearing column on the 5th of May.
Fine.
Heard the parties, admit. List again on the 5th of May in the hearing column.
I'm deep though.
Yes,
Lordship, kindly pass over the matter for time being.
Why?
Lordship, in this matter, the counsel for the petitioner, Mr. S. Biswas, is on his way, Lordship. He has not reached yet.
Now with so many flyovers, why is he on his way? He should have been here. Huh? Yeah, next continue. Yes, sir.
This is second bail application.
Huh?
This second bail application. After search sheet.
If your lordship permits me,
Ah.
sorry for that. Although I'm appearing for the informant, the other three persons have also filed bills and possibly they're listed tomorrow. It'd be better and prudent, my lord, as I feel so that all the matters are taken together. I make a submission, that's of course his versus mine.
Today, tomorrow, I will going to places. Today, I may be hard.
Oh, he may be hard, he may be hard.
I may be hard.
Tomorrow listed before this court?
Yes, yes, it's a second bill.
No, the other three. Other three also listed before this court or some other court?
This court, item numbers
Okay.
1, 2, and 20.
This was that child who had
Yes, yes,
committed
yes.
suicide after
She was raped.
she was
video
not
flash,
allowed
everything
to
done.
attend school.
I was
You,
nothing to do with that.
okay, yes.
Because secretary, I will go.
I also address that.
Yes, sir. Boli.
The the petitioner was arrested on 15/11/25. After he appeared before after receiving the summons. By the Posco court. Earlier, the main accused, Bhikkhu Secretary, who has done this offense against the child, he was arrested, he was the main one. I am the assistant teacher, I have nothing to do. I was only alleged of abetment of suicide. But in the search, there is no allegations of in the suicide note. The victim girl has stated about the headmaster and the Bhikkhu Secretary. You see, the FIR is on page 20.
20.
And the Azhar, type copy of the Azhar is on page 23.
23 years.
With due respect, I would like to inform you that my daughter Srimati so-and-so, aged about 13 years, is studying in 9th standard in Hatikuli High School. On last day on 3/6/25, my daughter consumed phenyl and fell sick, and teachers of the school admitted her in the Bora nursing home of Dunduma. On 6/6/25, after being discharged from the hospital, she told me that a few days back in the month of May, on 26/5/25, after school was over, a teacher of Hatikuli LP school, Sri Bhikkhu Secretary sir, has dragged her into the LP school kitchen and made her eat intoxicating substance and rape her. After coming to her senses, when she asked why she had done, the teacher threatened her not to tell anyone about the incident, and MC told them to leak the photos pertaining to the incident on social media. Therefore, as there was no other option, she had consumed phenyl. Therefore, it is my humble request for your good self to take necessary action as per law upon Sri Bhikkhu Secretary, who had destroyed the life of my daughter. This FIR was lodged on 9/6/25, and the girl committed suicide on incident was on 3/6/25, and the girl committed suicide.
After this, she again committed suicide.
Yes, on 6/7, after 1 month.
Okay.
On 6/7/25, 3/6/25, and 6/7, after more than 1 month, she has committed suicide. After that incident, that school for 1 month, he was never went to school. And in this regard, the headmaster, Bhikkhu Secretary, and the president on Kuladha, they arranged a meeting. They arranged a meeting of the guardians and whole staff and teachers. It is on page 75. May I read?
Page 75, na?
Page 75. To respect Sunil Das. Sunil is the father of the victim. Sunil Das. With due respect, would like to humbly inform you that in connection with the complaint made by your daughter.
What is the role played by this person?
He was present in the meeting as directed by the president and he, at the time of incident, all the staff has took the child for treatment. With respect, would like to inform you that in connection with the complaint made by your daughter, he has been decided to convene a meeting at the school.
Yeah.
The meeting will be held with the school management committee, the teaching staff and the guardian to discuss the matter. Therefore, you are hereby requested to kindly attend the said meeting at the school at 2 p.m. along with your family and daughter. This was the meeting on the same day in the night. They have lost the incident happened on 3/6. This was signed by Kulondo, the president of the school and the headmaster. I am nothing to do. As directed by the president, I was present in the meeting. Among me, other 15% were present. All staff, guardian, teachers. And in this regard, in the search sheet, page 32, your lordship may see the column 2 down below, page 32.
Page 32
Of the search sheet. One invitation letter from President SMDC Hatiguli High School and member secretary SMDC means the headmaster of high school on medical research certificate. This is the seized by the police. The headmaster and the president the president was not made an accused. He is not made a witness. They have arranged. I have nothing to do. And after 1 month, the girl have committed suicide. It is on page 42 in the search sheet. Page 42. Page 42.
Just a minute. They were initially granted bail during trial.
Yes, when they were, because the sections are bailable.
Bailable.
And subsequently,
This lady committed suicide.
these sections were added by the, in the search sheet, IO has inserted this.
You are reading page 32.
Page 42, page 42,
42?
page 42, about the instigation made by this headmaster and the culprit. Page 42, very unfortunately, the bold person, page 42. Very unfortunately, on 6/7/25, the victim of the case committed suicide at home by hanging. In a 4-page suicide note left behind, the victim stated that due to the misconduct by one Sri Bhikkhu Setri, she felt too ashamed to go to school. That the headmaster prevented her from attending school. I am not the headmaster. I am the assistant teacher. And not that being unable to sit her for exam, drove her to take her own life. This is the search sheet given by the IO. And against me, there is some allegations. Page 43.
Yes, I have seen. 3 teachers, they had, you had asked her not to report it and all that. That is the allegation.
It is about a version of the IO. But she never came to school after 9/6/25. After 1 month, she committed
When was the meeting held?
in a school
No, when?
in 9/6/25. The girl suicide on 6/7. About 1 month. And the incident happened on 3/6/25. And
Yes, sir. What is the particular role played by, where is the PP?
Madam, if lordship,
Mr. Parashar, you're there in the matter. I'll hear you. What is the role played by this person? Nikhil Devnath. Have you seen any specific allegation against him? No. You want to go through the PCA?
I have not controlled.
Yes.
When there is specific allegation, Malad, washing may not be possible. It's come for washing, not a bail. Not for bail.
It is for bail.
No, sorry, Malad.
The issue is the lady, the minor child was molested and by one particular person. She consumed phenyl, told her parents, FIR was lodged, school meeting was held. Whatever happened there, that is the main issue now. Whatever happened there, thereafter, they were released on bail. Filing of the charge sheet, they have been taken into custody. Okay? Now, Mr. Gogoi's contention is someone else committed the offense. In the meeting, he was present, the petitioner here was present with all the other persons. And it is only in the charge sheet that 3 people have been named to have stopped the person, the father of the victim from divulging the facts to other sources. The continued detention is what we have to look at. See, this PCR is here, go through it.
I'll just.
Yes, Mr. Bunik, what do you say?
Well, this is not a case of molestation. It's a case of rape.
Rape.
Videographed.
We are,
Rape and videographed.
that is by
Correct.
third person.
No, I'm not on him.
Uh-huh.
I said rape, videographed,
We
followed by
tried to
the
tone it
suicide.
down. We tried to tone it down to make him understand
Now,
the
Page
facts.
9, paragraph 11, he makes
Ah.
a statement.
Page 9,
Paragraph 11, he makes a
11.
statement.
Okay.
On this role, and the charge sheet says something more, but it's okay. Page 9, paragraph 11. May I read, may not?
Huh.
That the petitioner states that all allegations leveled against the petitioner in the charge sheet are false and baseless, and we specifically denied that the petitioner has any knowledge about the alleged incident prior to the meeting held on 9/6/2025. And on coming to know about the said alleged incident, the petitioner suggested the opposite party to go to the police station and lodge the FIR. Hence, no offense is made out. So prior to 9, he does not even know about the incident. That's what he
Okay,
said.
Then
My lordships, the matter which is listed tomorrow, therein they have annexed a statement of the girl when she was alive. Not the thing, not the suicide note, I'm on the statement of the girl. May I read that? It's vernacular, it's important. I'll not read the translation part. Or she would bear with me for not reading.
statement of the girl to your Thakibo na diyo.
I'll
Should be
read
here.
along. I'll read along. It has to be there. They're lying on the teeth of it. There was no reason to lie. And affidavit shown by an alleged nephew. I'm certain the client would not call him up to say all these wrong things. No, he's safe. I'm not on him. Absolutely wrong statements made. There's contempt now.
Just a minute. When she was alive, na?
When she was alive.
Ye gusso to mur maya dise. That one?
196. May I read that?
This is
More
on
now,
11.
Tikana, upor-
Just a minute. We were on the other part. 9/6 Tipali. Let's just read it out.
May I read? This was on 9/6. মোৰ নামো ঠিকনা ওপৰত উল্লেখ কৰা মতে সত্য মই হাতীগুলি হাইস্কুলত বৰ্তমান 9ম শ্ৰেণীত পঢ়ি আছো মই এই বছৰৰ যোৱা এপ্ৰিল মাহত কপাতলি এম স্কুলৰ পৰা হাতীগুলি স্কুলত নাম লগাই ভৰ্তি হৈছিলো হাতীগুলি হাইস্কুলৰ লগতে হাতীগুলি এলপি স্কুলখন লগ লাগি আছে হাতীগুলি এলপি স্কুলৰ শিক্ষক বিকু ছেত্ৰী ছাৰে মোক প্ৰায় বেয়া চকুৰে চাই থাকে যোৱা 26/5/2025 তাৰিখে দুপৰীয়া স্কুলৰ ব্ৰেক টাইমত মই স্কুলৰ সন্মুখত থকা দোকানলৈ গৈছিলো কিবা এটা কিনি খাবলৈ তেতিয়া বিকু ছেত্ৰী ছাৰে মোক কিবা দৰকাৰী কথা এটা ক'ব আছে বুলি ক'লে আৰু স্কুল ছুটি হোৱাৰ পাছত অলপ ৰ'বলৈ ক'লে মই সেইদিনা স্কুল ছুটি হোৱাৰ পাছত ছাৰলৈ অলপ সময় ৰওঁ সকলোবোৰ যোৱাৰ পাছতে বিকু ছেত্ৰী ছাৰে মোক হাতীগুলি এলপি স্কুলৰ ৰান্ধনীশাললৈ মাতি নি ৰান্ধনীশাল পোৱাৰ লগে লগে মোক টানি মুখত জোৰ কৰি কিবা এটা খুৱাই দিয়ে আৰু মই নিচাত ক'ব নোৱাৰা হৈ যাওঁ আধা ঘণ্টামান পাছত যেতিয়া মোৰ হুঁচ আহে মই কান্দি ছাৰক কওঁ যে মোৰ লগত কিয় এনেকুৱা কৰিলে মই মা দেউতাকক এইবোৰ কথা কৈ দিম বুলি কোৱাত বিকু ছেত্ৰী ছাৰে তেওঁৰ মোবাইলত মই বেহুচ হৈ থকা সময়ত তোলা মোৰ বেয়া কাপোৰ খুলি তোলা ফটো আৰু মোক বলাৎকাৰ কৰি
State of Maharashtra. Rihasa property versus State of Maharashtra. Similar issue was discussed.
Had the legislator wanted to make every offense non-bailable, it would have done so. Omission to do so cannot be regarded as an inadvertent omission. Your every sentence is being answered by this paragraph. Heard Mr. D. Medhi, learned counsel appearing for the petitioner, also heard Ms. Bora, learned APP. Full stop. This is an application under section 482.
483.
Now 483 of the BNSS 2023 in connection with Gauhati PS case number 23 of 2026. Full stop. The learned APP has submitted that the charge sheet has been submitted by charge sheet number.
Lordship, that number, it's there,
Where?
in the case record, Lordship.
In last order.
I don't have the case record. Where is the case record? By charge sheet number 61 of 2026, dated 26 to 2026. Full stop. The
43 case record. Not mine.
the learned APP has submitted that the sections involved are
21 small a, 25 and 29 of NDPS Act.
full stop. The learned counsel for the petitioner has submitted that since the provisions of section 27A have not been dragged in, comma, the petitioner would be entitled to the privilege of bail. Full stop.
Even if the 27A would have been attracted, in Riha Chakrabarti case, it was clearly defined. It will not come in the case of small quantity.
The learned counsel for the petition has submitted that offences under section 21A of the NDPS Act is bailable as has been held by the different orders of this court, including the order dated 3/1/2025, passed in AB number 3029 of 2024. This court does not find any reason to differ with the aforesaid findings, and therefore, in the opinion of this court, the petitioner herein is entitled to the grant of the privilege of bail at this stage. Accordingly,
Objection may be required.
huh?
Objection may be required.
The APP has submitted that. What? Objection saying what?
Lordship,
That the petitioner should not be allowed the privilege of bail at this stage, since there are chances that he may not participate in the trial and he may hamper and tamper with the evidence. Uske baad likhiega that part, huh? That part will come later on. In the opinion of this court, the petitioner is entitled to the privilege of bail. Accordingly, it is directed that the petitioner would be released on bail on furnishing a bond of rupees 20,000 with 2 sureties of the like amount, subject to the satisfaction of the learned trial court. The learned trial court shall impose such other conditions as may be required to ensure the participation of the petitioner in the trial proceedings. Here disposed of.
Deeply obliged, Lordship.
I mean, Article 16.
Yeah, please, Lord. Lordship, allegation was that. Allegation was that, Lordship, you are circulating pornographic contents in his social media, Lordship. Today's Lordship, 54 days, Lordship. Mandatory period 60 days, Lordship. Police already seized pen drive and mobile, Lordship. There is no chance of tampering, Lordship, the evidence. And when he was produced before the court.
If not in the meantime succeeded, my lord, thus I will take instruction.
Just after some time.
Item 14.
Extremely sorry, my lord, when this item was called, I did not get it. Courtesy to the new flyover.
Huh?
Courtesy to the new flyover connecting North Gauhati, my lord, with this. More than 1 hour traffic jam. Now, my lord, in this case, my lord, this is the second time when the CD has not been called, though I have instruction from my local council at Golaghat that charge sheet has been filed, but conclusively I cannot say.
I'll take instruction.
Let him take his,
Already-
if charge sheet is filed, TCR will be called for.
Where is the FIR?
My lord, the FIR, your lordship will find at page number 8. Otherwise also in the FIR, my lord, there is nothing.
In everybody's absence, 50 rupees.
Uh-huh.
In everybody's absence, 50 rupees being offered. That case? Okay. After some time, if the charge sheet is. One eight. Huh?
Trusted submitted.
No, have you read the last order? The IO gave him a notice to appear in December. Issued a notice in November asking him to appear in December and submitted the charge sheet even before the person appeared. So why is the custody required now? Spring for an AB. Go through the last order. 26, no.
Same, Thobri PS. It is a-
Notice is issued on 26/11, requiring him to appear on 8/12. Charge sheet is said to be submitted on 29/11. Sir, when the charge sheet is submitted, do we require to proceed with this?
The petitioner is not there now.
Diog after some time, apna after some. You are here in this matter. 18.
1890.
Sorry, madam.
Hmm.
Other court, your lordship. Under test. Charge sheet has submitted.
Charge sheet has been submitted. Are you still apprehending arrest?
My lord, my interim may be made absolute, my lord.
Huh?
As and when I
Where is your
receive-
interim? Was there an interim?
Yes,
There is
512.
interim. As and when he will receive someone, he will contest the case.
Heard the learned counsel appearing for the petition, also heard the learned APP who has submitted that the charge sheet has been submitted by CS number 402 of 2025 dated 29/11/2025. In such view of the matter, the interim granted to the petitioner on 4/12/2025 is made absolute. The petitioner shall appear before the learned trial court if, as and when he receives summons.
My lord, plus 18 and 19, same matter.
18 and 19, same, huh? 18, 19, both disposed of.
Obliged.
Yes.
The petitioner, my lord, is behind the bar for last 335 days, my lord. And then, that is 11 months, my lord. And she was alleged to have been possessing ganja, my lord, very commercial quantities, 27 kgs. And thereafter, my lord, charge sheet has already been laid in this case. Charge sheet has already been laid in this case on 36/2025. Now, my lord, the grounds on which she, for the lordship, seeking her release is at page 36, lordship, kindly.
Page 36.
That notice was-
What is this?
Page 36, my lord.
Ah.
It is notice under section 36, my lord.
Hmm.
Only lordship will find that it has been signed by the petitioner, accused and the officer, my lord, the arresting officer, and there is also signature of the, my lord, other person, which is required under the law, my lord. And I have also, my lord, checked the TCR, my lord. Yep. And checked the same, my lord. There is also no such.
No signatures on the arrest memo.
Yes, my lord. Lordship can have, I have marked.
And what about
Yes, my lord, the other page, my lord.
Materials, my lord, these are there, my lord.
copy of the WT is available?
My lord, that is lordship and TCR lordship will find, my lord.
The
Yellow flag mark lordship is perused. The yellow flag mark lordship is perused, my lord. That notice under section 36, just prior to that, my lord, that WT was there, but whether it has been served, my lord, it is not there, my lord. TCR,
that is creating a big issue now when people are all from the outside the state. They do not name anybody here.
As per the section 48, there should be a nodal officer in each police station, and if police sent the WT message or whatever may be, or a scan copy to.
Do we
that
have a
police
nodal
station,
officer here?
Perhaps.
Present status, whatever. But as per the 48, this is the process, and even if another police station, they may take a printout of the, if it is a scan copy, take a printout, and that can be served. But that is not the only WT message, that is we are also facing that problem.
So again on 48 and arrest memo, he becomes entitled.
Otherwise, for 27 kg of ganja, seized from that.
Where is your notification for nodal officer? Can we? Where is it?
Perhaps for section 37. 37. It is perhaps the thing by the senior is stating, but it is a covers section 37
Yes,
covers the same.
designated police officer, yes, section 37. 37B.
Yes, ma'am.
B is something else.
Even inform to a police station, if scan copy inform, then one case someday before he said sent in WhatsApp, and reply is yes,
Received.
received. So that is also but
There was an argument that by WhatsApp notices are not.
judgment, but
That is
WhatsApp notice
Satyendra Kumar until
until if WhatsApp notice you have been arrested, you have been arrested so and so and so. Only this. But if when the whole notice is sent,
And he says, yes, understood, received and understood. And then you say WhatsApp is not enough. Who said received and understood? Yes, heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP, Mr. K.K. Parashar. This is an application under section 483 of the BNSS for granting bail to the petitioner who is in custody since 24/2025 in connection with, you give this special NDPS case number at page number 1. The learned counsel for the petitioner has drawn attention of this court to the arrest memo of the petitioner to impress that there is no signature of any relative or any other witness to the arrest. He has also referred to the notice of information of ground of arrest issued under section 48 of the BNSS to impress that although there is a noting by the arresting officer that he did not get any relative of the accused person and therefore had sent a WT message from the local PS to the relative, full stop. The same does not disclose the name of the relative to whom the notice was addressed. And further, there is no record that the said WT message was ever served upon any relative, friend, or family of the accused person, full stop. The learned APP has gone through the scanned copy of the TCR available and has submitted that there is no record of the WT message having been served upon any person, and that the arrest memo available in the scanned copy also does not reveal the name of the relative or witness who was present, who may have been present at the time of the arrest of the petitioner, full stop. In view of the settled position of law that the when the provisions, when the mandatory provisions of section 35 and section 48 of the BNSS are not complied with, comma, the arrest and detention of the arrested person becomes illegal, full stop. In such view of the matter, this court is of the opinion that the petitioner deserves the benefit of a bail in view of the violation of the constitutional mandates. Full stop. It is therefore ordered that the petitioner be released on bail on prior to that, you write that, I did not write down that part. The petitioner has proclaimed herself to be a resident of a locality which is beyond the territorial jurisdiction of the trial court.
Yes, ma'am.
Full stop.
Neighboring.
Accordingly, strict conditions are required to be imposed to ensure her presence during the trial. Full stop. Accordingly, this court directs that the petitioner shall be released on bail on furnishing a bond of rupees 1 lakh with 2 sureties of the like amount, at least one of whom shall be a government servant serving either in the state or central government, and another shall be a person with immovable property. Full stop. The following conditions shall also be levied upon the petitioner while considering her release on bail. Those conditions from Parmenion and you take down, huh? 1, 2, 3, 4, 5, 6, 7. And at the end, you write, the learned trial court shall be at liberty to impose such other conditions as may be necessary to ensure the presence of the petitioner during the trial. Be a disposed of. Kita lole kete. Kita lole khobo lobo. Kita lole belo kete digaro dale se khobo lobo doka hale sing chorai. Yes, sir.
May I please, Your Lordship?
Huh?
Petitioner is seeking anticipatory bail
Huh?
in connection with an SC/ST offense. Your Lordship
Uh,
you will find the FIR at page 12. 2 sets of FIR were lodged and it was registered as one case.
hmm.
Your Lordship will find at page 12. There was some protest by the members of some organizations, wherein Lordship, it is alleged that the petitioners raised go back Chinese curfew. So this statement was raised and
They could have used the word "and." Everything would have been solved.
exactly, Lordship.
Eh?
But if Your Lordship at page 12, if Your Lordship peruses,
Eh? Page 12.
page 12 was lodged by Bharatiya Gorkha Parishang and ex-MSC. All these people belong to Nepali community. None of them are from the scheduled tribe or scheduled caste communities.
Okay.
And in the first FIR, they were not, the petitioner is not named.
Mm.
In the on the same day, just to make out a case of SC/ST, Your Lordship will find at page 15, the petitioner is named in the FIR. And this was lodged by Santosh Chauhan, who is the Assistant General Secretary, Karbi Anglong Hindi Bhasi Sanstha Central Committee, and Sri Ajit Das, General Secretary, Karbi Anglong Bengali Samaj Central Committee. So none of the members from the scheduled caste or scheduled tribe community had made an allegation that these people made some remarks against the Karbi community.
What is this other petition?
This writ petition, order of the writ petition, we have annexed just to show that the issue arises from an eviction notice issued by the Karbi Autonomous Council. In 2024, the Karbi Autonomous Council issued an eviction notice directing to vacate 11,000 bighas of land, wherein these all petitioners who are non-tribals, they reside. Now, seeking thereafter the
Yes, any further custodial interrogation required?
Lordship, otherwise,
Are they required to be in custody or can they appear and make their statements?
but they have highly raised some offensive comments.
Huh?
Offensive comments has been
Uh-huh.
raised by them
Huh.
against a Karbi community, Lordship. So otherwise, Lordship, CCTV footage has also been seized.
But then you had made a
Has been
statement
seized.
that some earlier bail application has been disposed of by some court.
yes, in respect of some other person.
What does it, what
They
was it?
They withdrawn.
They withdrew it or it was not decided?
It
That's
was not
what
decided, they
Lordship-
withdrew it.
Okay.
And CCTV footage of the entire incident has been seized.
Ah.
So that report is not received.
So do you need them in custody to go ahead with with the investigation is what we are asking you.
Please
We are
listen.
considering a bail. We are not considering the correctness of the allegations, are we?
Unmarried lordship.
Probability of the statements being correct or the allegations being correct
Lordship.
would have a bearing, but we are not deciding the correctness.
Lordship.
Even if they have shouted these words, for investigation, do you need them in custody or they are running around here and there is hampering the custody, the investigation?
This investigation is still going on, Lordship.
So we'll allow them to appear. Let them make their statements. If
Lordship,
the statement shows that they should be in custody or custodial interrogation is required, we'll
That is
cancel
what
that.
is required, Lordship.
From
Huh?
December to March, Lordship, the investigation is still going on.
They are also getting tired. I will also get tired.
In fact, all the offenses which are mentioned in the FIR, that attracts an punishment up to 3 years. So in fact, no notice under section 41A or which is now 35.
CD is not there.
Was
It is
issued.
there, Lordship.
Anything against them?
Lordship, yes, otherwise materials are there against him, Lordship. They have made some such offensive comments against a particular community,
Huh.
whereby harmony, disharmony creates. And
Yes,
He
take
said-
down. Heard Mr. Arbor Learned Counsel appearing for the applicant. Also heard the learned APP who has submitted that the CD has been received, full stop. The learned APP has submitted that there are some allegations against the petitioner herein on the basis of the investigation. However, this court is of the opinion that the appearance of the petitioners before the investigating officer would help in the investigation progress, full stop. Accordingly, how many petitioners?
Only one, Lordship.
The petitioner is directed to appear before the investigating officer on or before the 6th of April, 2026 to participate in the investigation, full stop. The IPP shall thereafter call for an updated case diary. List this matter again on 29th of April along with the updated case diary. The further, it is provided that in the event of the arrest of the petitioner in connection with PS case number, this, you give the PS case number, huh? In connection with Kheroni PS case number so-and-so, before the next date of listing, the petitioner shall be released on bail on furnishing a bond of rupees 20,000 with one surety of the like amount before the before the arresting authority to the satisfaction of the arresting authority. Step. Further continuance of the bail would be considered on after receipt of the updated case diary.
Much right, Lordship.
Yes, sir.
Yeah, my lord, in this case, when the CD was called for.
city receiver.
What has happened, my lord? The petitioner before lordship is the senior manager, my lord. He is of the finance company, Cholamandalam Finance. My lord.
Huh.
Now, my lord, for the purpose of a loan, my lord, as per the informant, she took, my lord, 4,29,000.
Where do we find it? The FIR?
FIR, your lordship will find it page 23.
23. You are Khurshid Alam?
No, my lord.
You are Khurshid Alam.
I'm Khurshid Alam Hussain, my lord.
Khurshid Alam or Khurshid Alam Hussain, Delhi.
There are two Khurshid Alams.
Probably, my lord.
One Khurshid Alam sold my auto so-and-so to accused number 1. When a motor the accused should the EMS will pay regularly and paying the owner of the vehicle amount of taken the
Lordship will see the loan application will lordship will find at page 28.
Huh?
Loan application, my lord, by the informant at page 28. Then,
Just
my lord,
a minute.
page 32 is the statement of accounts, my lord. Your lordship will see the right, my lord, amount finance is 4,29,000.
Page 30?
32, my lord.
32 years.
It is a statement of accounts, my lord, of the loan, my lord. And in fact, my lord, she defaulted. And in between, my lord.
But she says you are the salesman.
No, I'm the senior manager. I'm the senior manager of the finance company. I'm not nothing to do with the sales.
Okay.
Now, Lordship will see kindly come to page 56, my lord. There is a demand notice for default. And ultimately, my lord, we filed a case before the in Kolkata. That has referred in one of my paragraphs. Now, what has happened, my lord? What the informant she sold of the vehicle to one Abu Hanif Ali, which Lordship will find at page 60. My lord, unless and until the hypothecation is removed, my lord, the vehicle cannot be sold off. Here is a case, my lord, if your Lordship kindly comes to page 60, is the agreement between the informant Rahima Bibi and Abu Hanifa.
Page 60.
60, my lord.
Page 60 is an agreement. Yes.
Page 61, my lord, your Lordship will see the name. Rahima Bibi is the.
She's at the top.
Yes. She is the informant, my lord. Now, these are the, we have nothing to do. So she sold off the vehicle to some person, my lord. He failed to make the payment. And in fact, my lord, we have filed a case. And my lord, after receipt of the notice from the court, my lord, that is CS 2803.
No, here it is said that the rejection of your earlier bill petition says that it was sold off with the help of the accused petitioner.
No, my lord, I cannot be, my lord, because if your Lordship sees, what role have I played? Have I to play? Even if your Lordship sees the order, sorry, my lord, the page 63, my lord, the witnesses. I am nowhere in the picture, my lord. And who is this Khurshid Alam? That is also not.
You are also Khurshid Alam.
I am Khurshid Alam Hussain, my lord. I am the senior manager of the Cholamandalam company, my lord, located at Dhubri. And if your Lordship sees, I have annexed the, my lord, identity card as well.
And you are not working in the showroom.
No, my lord.
Yes.
I am the senior manager.
Yes, madam. What does it say? What does your CD say? He says he's not even the man named in the FIR.
19 is my lord, identity, my lord.
Lordship, after some time.
Find out if he is the man who was involved in the sale. If he is not, similarity in the name, can he be taken into the fold of this, whatever cheating the other person has done, after some time? I'll just come back in 2 minutes, sir.
This present petitioner is one of the staff of the Sona Mandalam Finance Company. So he accordingly, he has approached before the complainant. Lordship, may I read her statement, Lordship? Statement of complainant Rahima Bibi. Apuni kam kore. Yes, I am a housewife. So and so number alto car owner kun hoy. Ekhon alto car owner moi hoy. Moi October 2022 Bilasi para Maruti dealer para etu e alto car khon kinu. E Maruti dealer para Mehbub namor ejone muk Khurshid Alam namor Cholamandalam Finance Company মানুহৰ লগত লগ কৰাই দিছিল। উনি কাৰখন আৰু কিয় সেল কৰিলে? কাক আৰু কিয় সেল কৰিলে? এই গাড়ীখন মই 2022 অক্টোবৰত কিনি ৰুপিজ so কৰি 1.5 বছৰ মান EMI দিছিলো। পিছত আমাৰ পইচা প্ৰব্লেম হোৱাত আমি মাহত দুটা EMI দেৰিকে দিয়া হৈছিল। সেই কাৰণে ফাইনেন্সৰ মানুহ ডেইলি আমাৰ ঘৰত আহিছিল আৰু খুৰশিদে নিজে বহুতবাৰ আহিছে। খুৰশিদ আলম আহি আমাৰ ক'লে যে আপোনালোক দুখীয়া মানুহ সেই কাৰণে EMI দিব নোৱাৰে, তেনেহলে মই কাস্টমাৰ লৈ আহো, আপুনি এগ্ৰিমেন্ট কৰি বিক্ৰী কৰি দিয়ক। খুৰশিদ আলম দুটা কাস্টমাৰ আমাৰ ঘৰত আনিছিলে, কিন্তু আমাৰ দাম নিমিলা কাৰণে আমি এতিয়া বিক্ৰী কৰা নাছিলো। এদিন খুৰশিদ মোক কল কৰি মোক জনাই যে এজন কাস্টমাৰ আহিছে, আপুনি গাড়ী লৈ তাত অফিসত মাতি।
This man was required to appear before your authority.
Lordship.
Has he appeared?
Yes, Lordship, he appeared.
Earlier also, my lord, his statement was recorded.
Well, what did he say?
Lordship, may I read his statement?
What did he say?
Yes. কেতিয়াৰ পৰা চিনি পায় আৰু কেনেকৈ? কমপ্লেইনেণ্টক আপুনি কেতিয়াৰ পৰা চিনি পায়? যোৱা 2023 চনত যেতিয়া মই sales executive আছিলো তেতিয়াৰ পৰা মই ৰহিমা বিবি কাষ্টমাৰ হিচাপে চিনি পাওঁ এজ এ sales executive মই যেতিয়া মানুহক গাড়ী ল'ব লাগে তেতিয়া মই লোনৰ কাৰণে ফাইনেন্স প্ৰভাইড কৰিছিলো আপুনি ৰহিমা বিবি কেনেকৈ লগ পালে 2023 চনত মোক ডিলাৰশ্বিপৰ পৰা মাৰুতি সুজুকি ডিলাৰত লিড দিছিলে মেহবুব বুলি এজন মানুহে আৰু তেওঁ মোৰ ৰহিমা বিবিৰ লগত চিনাকি কৰে ৰহিমা বিবি ফাইনেন্সৰ গাড়ী আপুনি কাক কেনেকৈ সেল কৰিছে মই সেল কৰোৱা নাই ৰহিমা বিবিয়ে নিজে আবু হানিফ নামৰ এজন কাষ্টমাৰ আনি he is not admitting lordship otherwise
But he is the same man. He is the sales executive. He is the same man.
yes
Even otherwise.
He has now gone up in his
yes he's the same
career, but otherwise he is the same man. Huh?
Sections, my lord. How can I be implicated, my lord? There has to also be to see, my lord, because
the-
we say cheating and breach of trust.
again one
The
question
person who buys it, my lord, he doesn't pay. He lodges an FIR against that person. How am I involved, my lord?
Lordship, one more question has been put to him lordship
Ah.
ayo apuna লোকে ফাইনেন্সৰ পৰা EMI নোপোৱাত গাড়ী এগেইনষ্ট কি একচন ললে ৰহিমা বিবি কাৰখন বিক্ৰী কৰাৰ পিছত 2-3টা EMI পেইড কৰিছিল কিন্তু যেতিয়া ৰহিমা বিবি 3টা EMI ফেইল হয় তেতিয়া বাই পোষ্ট ৰহিমা বিবি এড্ৰেছত চোলামণ্ডলম ইনভেষ্টমেণ্ট ফাইনেন্স কোম্পানী লিমিটেডত হেড অফিচৰ চেনেৰ পৰা কাৰৰ প্ৰি-সিজাৰ লেটাৰ গৈছিল আমি গাড়ী বিচাৰি ৰহিমা বিবি ঘৰলৈ গৈছিলো so there is some nexus
No, the nexus is not to the extent that he is involved in the cheating part.
Cheating
He
part
might
is
have
not there.
helped, see,
That is not there.
the cases under cheating. Now, he helped her sell the car.
Yes.
Even if we assume that to be true, how is he involved in the cheating part when the other person does not pay the installments? Heard Mr. Swensol and a counsel paying for the petitioner, also heard the learned APP who has submitted that the CD has been received and the statement of the complainant has been recorded
yes
by the investigating officer in view of the above circumstances. Since the CD does not reveal the requirement of an custodial interrogation of the petitioner herein, the interim bail granted to the petitioner earlier is hereby made absolute. The petitioner shall appear before the learned trial court if, as and when summons are received. Huh? At the top, you heard Mr. R. Day, and a counsel for the petitioner. Dio.
Your lordship, herein also, notice under section 48 has not been issued. Your lordship.
How did it prejudice you?
I am arrested by Silchar PS on, we, two petitioners, on 7/5/2023. Your lordship. Herein the petitioner number 1, your lordship, he is a driver by profession and the wife of the owner of the vehicle requested him to bring back his husband who was at treatment at Gauhati, Raman Hospital.
Just a minute.
On the way, your lordship, the wife of the petitioner has been dropped, wife of the owner has been dropped, and thereafter on the way, the car was intercepted and
You had requested the wife of the owner of the vehicle.
wife of the owner requested me, I am a driver.
Ah.
Petition number 1 is a driver. And petition number 2 is a co-driver and is relative. The wife of the owner of the vehicle requested me to take the car and bring back his husband, her husband, who was under treatment at Gauhati Raman Hospital. So on the way, she was also along with us. On the way, she dropped to at Hailakandi. And while coming to Gauhati, at Silchar, the car was intercepted and
Okay.
recovered your lordship. Now we are arrested on 7/5/2025. Arrest memo is annexure number 2 and 3, page 18. Page 18, your lordship. So-and-so accused, Amu Khan, so-and-so, signature. Below only the signature of the arresting investigating officer, your lordship. The next page is the arrest memo of petitioner number 2. But no notice under section 48, your lordship.
Have you seen it?
48 is there, but it is WT message.
Same.
WT message. Otherwise, malat here, malat otherwise, malat up to PW 8 already examined. PW 1 and 2. As per merit, malat PW 1 and 2 they have malat, implied malat.
1 and 2 examined.
No, up to 8.
8.
Up to 8. 7 is forensic officer. All are there, malat opium, heroin,
All samples. Oh, so it was a showroom carrying the samples. Huh?
But 48 malat WT message and 36 malat.
That order you had taken, na? Earlier I had given that 48, section 48 and section that arrest memo. That order you had taken. Some time ago I had disposed of that matter.
Item 12.
Item 12. Huh? You have taken that order, no? It will be a similar order. The case number will change. And here the person should be
2 person. Ahmed Khan.
Application under section 483 in connection with NDPS case number 742025. Huh? The rest the body would almost remain the same. Disposed of allowed. You have to find out some means to, and that arresting part.
Arresting, now earlier they have complied this, now after 47, 48 came, they forgot that, 36. That part earlier, in earlier process, that was complied.
In those NCB cases, we have noticed the persons usually come from other forces. The NCB is a deputationist force. So persons from the CRPF, BSF, ITB, they picked up and sent off as these dead parties. They know nothing about the BNS or the CRPC. They know nothing about it. Not trained enough. They simply pick up and things keep on going. Yes, this is item 14.
14 to
30.
And that is disposed of. Your item is disposed of.
14 regarding charge sheet submitted or not, not yet received.
Otherwise also I have read the FIR twice, my lord. Perhaps 49 days in my whatever little I understand. My lord, detention for the sake of detention is something else. If they derive some sort of extra celestial pleasure, my lord, that's something else.
The pleasure was sought to be derived by the accused.
Ought to be not 49 days was in custody. Whether for such an offense, any custodial detention is required.
We just got the information, charge sheet submitted number they are providing.
Then it's a very good case for bail. Investigation is over. Then I'm deeply obliged. I'm deeply obliged. I'm deeply obliged, madam.
There are materials are there, madam.
Material na thakle bail file ko kono koribe na. That is also tried. And after 5 days, the affair is lost. The affair is lost after 5 days. Nowadays, it became difficult even to charge somebody.
What do you say, madam?
Actually, the effort minor in the she is only 5-year-old girls. And he is giving 50 rupees in the 50.
In fact, he was giving this 50 rupees to buy chocolate, my lord. Now, that is the issue, my lord. A 5-year-old child, how he has taken. And
the, alone in the house.
And the age is 9 years, not 5.
9
years.
9 years. And FIR also says that he tried. Prima facie, believing it to be true. Whether 49 days is not enough.
And they released the victim.
But once the charge sheet is submitted,
investigation is over.
Either the we'll either have to see the scan copy or you'll have to approach the trial court. What is to be done? Tell us.
Since your lordship has given these two options, then I'll prefer for the later.
You'll try that.
No, yeah.
The learned APP has submitted that the charge sheet has been submitted. We'll stop learned. Counsel for the petitioner has submitted that once the charge sheet is submitted, there is no further requirement of custody of the petitioner. Stop. This court is of the opinion that a perusal of the ECR would be necessary to find out the extent of requirement of the petitioner being kept in custody. Accordingly, call for the TCR. List again on 6th of April.
My lord, TCR, my lord, subject to correction, my lord, because if your lordship says TCR, because your lordship has not indicated which case number, which court. So again, it will create another difficulty next year, so nothing will come. Now it is for them to.
They will supply it. He still has
TCR TCR from
in connection with. Okay, we'll put down the detail.
in connection with Gauhati PS case number, that may be
Gauhati PS case number
31 of 2000.
31 of 2026. List again on the 6th.
Item 15.
Nagari. So, he have his.
16.
Hmm.
16 malad, yes, case not filed. Till now, such is not filed.
Lordship, today is 54 days, Lordship. And when the accused petitioner was produced before the court, Lordship, police has not sought police custody, Lordship. So further interaction is not required, Lordship.
We'll allow it. Huh?
Malad?
Heard Mr.
On length of detail.
M. Burwal and counsel appearing for the petitioner also heard Mr. Parashar, the learned APP. Full stop. The petitioner was arrested in connection with the casualty PS case number 24 of 2026. On
1/2/2026.
on 1/2/2026. Full stop. This court in the earlier order had noticed that the FIR had been lodged by a police authority who acted upon information received from the Cybercrime Coordination Center, and there is no identified victim in the matter. The counsel for the petitioner has submitted that at the time of production after the arrest, the police did not seek custodial interrogation of the petitioner, and now he has spent around 47 days.
54 days.
54 days in custody. Stop. The relevant, what have been seized?
One pen drive, Lordship.
One pen drive has also been seized. Full stop. In view of the above, although the learned APP objects to the grant of bail, this court is of the opinion that the petitioner can be granted the privilege of bail. During the investigation period, full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of ₹20,000 with two sureties of the like amount, one of whom shall be a responsible person having influence over the petitioner to the satisfaction of the learned. Whom? CJM.
CGM.
Learned. Huh?
Dashboard also.
Learned CGM textbook. The petitioner shall not indulge in any activity regarding social media during the time of his bail. The learned judicial court shall have the liberty to impose such other conditions as may be required to ensure the participation of the petitioner during the investigation. Bail application disposed of.
All right, finding item 5 and 6.
Lordship, JMFC Sunitpur Tezpur Lordship.
JMC Sunitpur Tezpur Judicial Magistrate.
Obligation.
Yes. This was some transfer
Sorry,
petition.
but I was on legs.
No
This
issues.
is seeking transfer of a case, my lord,
Hmm.
pending before the court of Tejpur.
Hmm.
Only on the ground that since one of the accused person is an advocate of Tejpur Bar Association, so he has the apprehension that there may not be a fair trial.
Hmm.
So this is the only apprehension. Under this apprehension, he has filed the case. But he seeks to transfer the case either in Nogao or in Bishnath Chaile, but the place of occurrence is in Tejpur. The witnesses are available in Tejpur. But in exceptional circumstances, the question would have been different, like in the Abhinil case, my lord, where the most of the accused person belong to a particular area. So in that case, it was transferred to Nogao. But this is not an exceptional case, as my lord, we find under section 447. I can say only one ground at page 22,
Hmm.
page 13, paragraph 22.
Hmm.
The petitioner begs to submit that owing to the considerable face value and influence of accused respondent number 2 in the local bar, it may be reasonably presumed that such influence has created serious impediments in the process of getting justice. A charge sheet has been filed, then the trial is on its way. And some vague apprehension and on the basis of presumption, he has filed this application.
Just a minute. On a mere apprehension, should we resort to
Because-
transfer?
Yeah, I want to submit before Lordship that
Hmm?
the list of death matter. That is
একটু admission ওখানে আইছে নাকি?
not only apprehension matter, you are also very. You put at the apprehension matter in the orders, last order matter. May I please your. You are also pleased to see the last order passed by your Lordship. 12/12/2025, my lord. Paragraph 3, the learned counsel for the petitioner by drawing the attention of this court to the documents annexed to the petition has submitted that there appears to be an apparent miscarriage of justice in this case. Inasmuch as the respondent number 2 and 3 are the arraigned as respondent number accused number 1 and 2 in the aforesaid case, were allowed to go on bail by order dated so and so in criminal miscase number so and so, my lord.
Uh-huh.
Paragraph 3, my lord.
Of what?
Of
We'll
the
admit
Lord-
this,
Lord-
we are not convinced that only on an apprehension the case can be transferred.
Apprehension, my
So
lord.
what we will do is we'll admit this petition,
My lord?
we'll admit the petition.
No, my lord. May I pray that, my lord, may be taken after vacation, my lord?
Huh.
I do not want to kept it pending, my lord, because the trial is already sufficiently delayed due to their intervention, my lord.
What is the stage of the trial as of now?
Proceeding stayed, my lord, at this.
By this?
Yes,
My, you also at least see the factual aspect, my lord. FIR was filed on 2016, my lord. Charge sheet was filed on 31/1/2019, my lord, after
Ah.
3 years. After
So?
3 years, charge sheet was filed, my lord.
Huh.
Thereafter, my lord, case remained pending or only for the remain pending in the CGM court, my lord, for almost 3 years, my lord. Thereafter, they took 3 years for service of notice, my lord. Also, that
see that aspect of the matter, how they are influencing this case, my lord. 3 years remain pending in the police station, my lord. The FIR law 19/9/2016, but charge sheet was filed on 31/1/2019, my lord. I have rounded the portion, my lord, list of date, my lord. And thereafter, my lord, though record came to the court, my lord, but it took more than 2 years to put up before the learned CGM, my lord, for service of notice. And they took 3 years time for service of someone on the.
There was no postmortem on the.
Done, my lord. Everything was done, my lord. Also observed it, my lord. How it on the
The
next
influence
day,
appears to be there.
My lord, he committed suicide.
So there must have been a postmortem report.
My lord, they are.
Unnatural death, there has to be a postmortem
Yes, my
report.
lord.
And now the APP stands up to say that yes, there was no postmortem report. We don't know how he died, so please grant him the pre-arrest bail.
But
And you say there is no influence.
it was the submission of the APP on what?
So he's the
not
accused is
PP,
having his
PP,
influence.
PP, my lord. At that time, PP was submitted.
Whatever.
My lord, now the trial is going on and the charge sheet, my lord, the case is in session, my lord. And the court is, my lord, court is sitting on the matter, my lord. He is, my lord, the learned court is looking after the matter. Now he is blaming the court for the.
The issue is not whether the learned court would be able to come to a conclusion or not. The issue is whether on the facts which are already before this court, there is an apprehension that the case may not be conducted properly. Have you seen the last order?
My lord, yes.
By this court?
Yes.
You've seen the order.
There
There is no denial to that fact.
But that.
Denial to the fact that when records say it is an unnatural death, and when the prosecution stands up to say that there is no postmortem report available.
Well, whatever was the investigation done by the investigating authority, that charge sheet is filed.
The charge sheet is a separate thing. Now, what about the conduction of the?
Well, PP is submitted only on the basis of the record available before him.
Apparently not, because the record has to contain a postmortem report.
Yes.
It had to contain one.
Yes.
Then.
Well, they have also received the copy, my lord, at the time of appearance.
The apprehension is, look, there might be some lapse in the prosecution.
The lapses has to be, my lord, there has to be some credible information.
That information is here.
My lord, this learned PP has submitted only on the basis of the record available before him, my lord.
Could it be? Tell us, could it be?
Cannot be, my lord, but
then,
but then also, my lord, then record has to be seen whether the, my lord, postmortem report is available before the court or not, my lord. And whether in fact the postmortem
we'll have it on the 21st for disposal.
My lord, CD, my lord. What, or your lordship, they're going to dispose of?
Not now, but we'll dispose it of immediately on the reopening. By the order dated 12/12/2025, this court has noticed that not only
APP has also, my lord,
there was no proper objection at the time of grant of pre-arrest bail to the respondent number 2 and 3 herein, the learned PP had also raised objections to the prayer made by the counsel for the petitioner herein to assist in the prosecution. Full stop. It is on those grounds that the petitioner had expressed an apprehension that the conduct of the trial may suffer, since one of the accused person is a counsel, is an advocate of the bar in which the trial, bar of the court in which the trial is proceeding. Full stop. Mr. S. Biswas has entered appearance for the respondent number
2 and 3.
2 and 3. Stop. List this matter again on April 7th, 2026.
Maybe
By which time?
Maybe after vacation, my lord.
On 23rd of April?
23rd.
Of April, by which time the respondents would be at liberty to file their objections, if any. And yes, Mr. Burua, The accused is a advocate of the same bar. Case is one of unnatural death. Pre-arrest bail applications were filed. PP makes a submission in the court that there is no post-mortem report. The man is sick from many days ago, so pre-arrest bail may be granted. Pre-arrest bail is granted. The petitioner's counsel makes a prayer that allow me to assist in the prosecution. My son has died. Rejected without a reason. He wants a transfer of this case to some other court. Have your instructions. The role being played by the prosecution there needs some attention of the prosecution.
They have to one thing, my lord, case diary already here, my lord. In another case, my lord, they filed the petition for quashing, my lord. There is scan copy of the CD is also there, my lord. May I pray one thing, my lord? Record may kindly be called for up 2 missed cases, my lord.
The learned counsel for the petitioner has prayed for calling of the record, scan copy of the records of
Missed case number, missed criminal case number 620 of 2016
and
625 of 2016.
from the court of session judge.
Session judge, yes.
So it put full stop. The same be called for. The learned PP shall also have his instructions on the issue as to whether the prosecution is suffering and the prosecution is exhibiting laxity
CD is here.
in the allegations leveled by the petitioner. Have your instructions on this. See, if there is an unnatural death and a pre-arrest bail petition is moved, can it be the case that it will be in the absence of a post-mortem report? There has to be a post-mortem. Submission is made that we don't have a post-mortem report. Then there is a recording in the order that he was suffering from several previous diseases. From where that record has come?
That's why, my lord,
Charge sheet comes
missed case
3 years
record.
later.
They may have,
Huh?
they may have probably made wrong submission in the bail petition, my lord.
Then
That may be, my lord.
the request to assist goes. The counsel cannot argue. He can only assist the PP. Why is the request rejected? There has to be some reason why it is to be rejected. And then the delay.
By the court.
Huh? So we don't want to go into the records who was the PP then, who made a submission like that. Why did he do it? That will be within your realm. Have the earlier order forwarded to the director of prosecution to find out what went wrong.
That also can be done.
No application for cancellation of bail on a wrong statement made. Had it been on the merits, the issue would have been something else. Absence of a PM report in an unnatural death case calls for disciplinary action, calls for a request to the bar council to take up a disciplinary action against the person who made such a statement. We have seen the objections raised here, and we have seen the order passed in that case. Yes, the state government has now taken up quite good steps, having proper persons being appointed as PP and whatnot.
That process is already going on. my lord.
That part, what happened? His apprehension is genuine.
There should not have been the submission of the petition.
Cannot be. And therefore his apprehension that that man is using his influence at the bar.
Not, my submission is reversed, my lord. Advocates are influencing for him because of his standing in the bar. That is my.
Whatever it is. Trial cannot proceed like that. Trial has to be fair. Not only to the person,
My lord, already
not only to the person who's facing the trial. It also has to seem a fair trial for everything. Decisions, whatever they come, they come.
Obliged, my lord.
Much obliged.
Well, this matter may be disposed of.
Huh.
Its FR has been rejected, the final report. With your
Has been
lordship's
rejected.
direction, we have approached the learned trial court,
Hmm.
then a petition.
Hmm.
And
And the learned trial court has sent it for further investigation or has?
yes, further investigation.
Further investigation, yes. Heard Mr. S. Biswas, learned counsel appearing for the petitioner, also heard the learned APP. The Mr. Biswas, learned counsel for the petitioner, has submitted that the final report, which was under challenge in this criminal petition, What did you say? What was your prayer?
My prayer was that after the submission of the final report, the case was closed.
Ah,
So there was no order passed.
Mr. S. Vishwas, counsel for the petitioner submitted that when the entire proceedings have been closed on submission of an FIR, the petition of an FR final report, the petitioner had approached this court challenging the order of the learned Special Judicial Magistrate Kamrup Metro in connection with dispute police case number 4048 of 2021. Full stop. Mr. Biswas has submitted that on a petition being filed before the learned trial court raising grievances against accepting the final report, comma, the learned trial court has, by the order dated 13/3/2026 passed in dispute PS case number 4048 of 2021, rejected the final report and has directed and has remitted the matter back for further investigation by an officer not below the rank of Deputy Superintendent of Police, who would conduct an independent, objective, and time-bound investigation addressing specific queries noted in the order itself. The learned counsel for the petitioner submits that for the time being, the grievance of the petitioner stands redressed, and this criminal petition would not require any further adjudication for the moment. Full stop. Accordingly, the criminal petition is closed. Petitioner would be at liberty to raise any future grievances without reference to this criminal petition. No, without reference to the closure of this criminal petition. Yes. Yes.
This matter is awaiting appearance of the informant.
Ah.
Conviction is under section 8 of.
Yes. Do we have any reports, sir?
If service report has come back on the last day.
Huh?
Service report has come back.
Let's come back.
Yes, service come.
Saying what? Served. Where? Where is the service report? No, where is the service report? It we have our case to write was
That recorded in the last order, 17/3.
None appears for the informant. No, we recorded it, but we do not see where it has been. Notice has been issued.
No, madam, that we have received, madam, service report.
You have received
Yes,
the service report. Okay. None appears for the informant, although the learned APP submits that the service report is complete as recorded in the earlier order itself. Full stop. In such circumstances, this court appoints A. Fukon as the learned, as the amicus to assist the court in the matter and protect the interests of the informant and the victim. Full stop. Learned counsel for the petitioner to serve copies of the criminal appeal upon the learned amicus within a period of 2 days from today. Place this matter again on the 9th of April,
Yes.
2026.
9th is a holiday, madam.
Yeah? On 9th of April is a holiday. It will
After Bihu, madam. 9th, 10th is holiday, madam.
Even 10th is a holiday now. On the 21st of April.
Parts 1, madam.
21.
21, madam.
Obliged.
May I please, Your Lordship?
Yes.
Lordship, in this case, appellant was convicted under section 304B IPC for rigorous imprisonment for 10 years. Lordship. His other side has to be yet to be filed the objection, Lordship. Objection not filed.
In the last order, we have recorded that it will be taken up for disposal finally. Why is it come up for orders? Orders or Orders or Yes, sir. When can we take up the appeal for disposal?
Fix after the month of May, madam.
Huh?
The month of May, madam.
What is your ground? Ground of appeal. What is your ground of appeal? Main ground of appeal? Huh? The earlier order in the IA criminal has reflected that the matter was supposed to be taken up for final disposal since the TCR has been received. List this matter on, or list the criminal appeal on 4th of May 2026, when an attempt shall be made to dispose of the appeal. In case the appeal cannot be disposed of, the consideration of suspension of the sentence would be considered. 4th of May.
Item 24.
For hearing kolu no? On the 4th of May.
May it please your lordship. Lordship may kindly pass over the matter for the timing. My senior is on legs.
Okay.
At 2.
We'll not say it.
For at 2.
We'll not say at 2. We'll say we'll see when the matter reaches.
Obliged.
25.
Yes. Any settlement arrived at? No.
My lord, he is ready, my lord.
They are not ready. Why you are not ready?
My lord, there is a judgment of the apex court, my lord, recent judgment. my lord.
Saying what?
It is saying, my lord, the petitioner, my lord, accused petitioner can, my lord,
Do what?
pay money, my lord,
Pay what money?
it's fine money, my lord.
So pay the fine money and
My lord, as per this judgment, my lord, I have no objection.
compensation of 4,50,000. You are ready to pay?
Yes, my lord, by installment from next month, my lord, I will pay, my lord, 50,000 per month, my lord.
Installment is allowed.
Not much.
Where? Where does it say installment allowed?
My lord, earlier, my lordship kindly able to, earlier one judgment, it is page, para 37.
Page 37 of this.
In this judgment, my lord.
Ah.
And these guidelines was later in this judgment, it is modified, my lord. And it was by modification, same thing, just interest rate is less than page 30, para 38. And para 38, my lord, it was provided, my lord, then last page, my lord, under 6, I am coming under 6, my lord.
Under?
Under 6, my lord, last page, my lord. C.
C.
C, my lord, last page under
After
clause C.
is made before the Sessions Court or a High Court in revision, such court may compound the offence on the condition that the accused pays 7.5% of the check amount by way of costs. So you have to pay the
I am under C, my lord, last page, my lord. Similarly, if the payment of tax amount is made before the session court or a high court, the revision or appeal such court may compound the offence at the condition that the accused pays 7.5% check amount by way of cost. Now, my lord, conclusion.
No, you have to pay the check amount also.
Yes.
Now,
my lord, conclusion part, my lord, here it was, my lord, 7,50,000, and it was provided that, my lord, in each month 50,000 to be given, my lord. So there, my lord, I took instruction, my lord, he will, from my lord, first week of my lord, May, my lord, he will pay, my lord, 50,000 per month, my lord.
Lordship may fix this matter next week.
why? We'll fix it in.
And similar order, my lord.
We'll fix it in the next month, so that he can show proof of payment of 50,000.
This is the order, my lord, this court also passed, my lord, recently, my lord.
Your Lordship,
You need the money.
Your Lordship, kindly peruse the order dated 23/1/2025. From 2025, they are saying that they will pay.
No, we'll fix it on the next month. If he comes back with a payment of 50,000, good enough.
So I have to take instruction from my senior.
You don't want the money.
Lordship, I have to take the instruction from my senior.
He wants the money. Client, we do not know. Huh?
I have to take instruction from
Because
PK.
better for him also.
Yes.
Okay, then Lordship, they're saying my senior has instructed me that even if it is an installment, then a sum of 5 lakh rupees.
No, it says this court
Because
has
your Lordship, there is
on the same
imprisonment of
on almost on a higher amount. Your amount is 4,50,000.
4 lakhs 50,000.
On a higher amount, Supreme Court has said 50,000 per month. Yours is a lower amount.
Lower amount.
We are still going for 50,000 a month. So that will take you 9 months.
Then the date may be fixed. Your Lordship.
And then there will be 7% cost also.
7%.
7.5% cost of the check amount. Check amount was 225.
4 lakhs. Your Lordship.
4 lakhs.
4 lakhs.
So that will also come in then.
Up to your lordship, here, my lord, conclusion part, my lord, 7 lakhs, my lord, and it was provided. 1,50,000.
No, you have depended on C.
See, my lord.
C says you may compound the offense provided you pay 7.5%
Then what
of
would
the
be
check amount.
What is the, my lord, amount, my lord, now, my lord?
The amount will, that calculation also we have to make.
I.
Huh? 4 lakh 7.5 kiman hai? 7 for the 28 to 28,000, 30,000, 35,000 more. Then, so we'll say we'll list this matter on 20th of April, by which time you would have paid the cost and the first installment of 50,000. So you would have paid 87,000.
Yeah.
We'll record that. Heard Mr. Borvian and Council appearing for the petitioner. Also heard Mr.
Your Lordship.
appearing for the
Sole respondent.
sole respondent. Full stop. The learned counsel for the petitioner has submitted that in accordance with the judgment of the apex court in criminal appeal number 1755 of 2010, Sanjabij Tari versus Kishore S. Borkar and another, the petitioner is agreeable to pay the 7.5% of the check amount by way of cost and also pay the compensation amount of rupees.
We also divided with installment, my lord.
Nothing doing. Nothing doing. Not in so much of piecemeal, sir. 7.5% of the check amount by way of cost as also a sum of rupees 50,000 per month to satisfy the financial liability upon the petitioner. Full stop. Mr. Borvia has submitted that the amount of rupees 50,000 as the first installment shall be paid within 10th of April 20.
In the month of April.
Give us a date.
Better maybe fixed on, my lord, last day of April, my lord, then in the meantime, you will pay, my lord.
On 30th of April, and the first installment of 50,000 rupees shall be made in favor of the respondent on or before 24th of April 2026. The cost amount of 7.5% of the check amount shall be deposited along with the second installment, not the first installment. You do it on the second installment. Second installment. List this matter again on we said 30th of April, na? Yes.
Deeply obliged.
Apply. 26.
My plea, Lordship. My lords, fifth, 11. I can be looked into, Lordship.
Order dated 7/3/2026. First tell us that.
Lordship.
Proof of
Yes, Lordship.
maintenance.
So other 2 occasions, case got listed, your Lordship, vehemently controverted that amount directed to be paid, rupees 1,000 not been paid. Right from the very inception, your Lordship, I have been paying, you Lordship. Let us have a copy. Copy to just pricing all about it. Because your lordship, the order was on 5/5/2022.
You were required to pay
1,000, your lordship. As per
Huh?
order dated 5/5/2022, your lordship. Honorable, records order, your lordship. 5/5/2022, your lordship. Impugn order of the state and your lordship down below,
and nothing to the respondent number 1.
lordship.
Where is that payment?
Payment, your lordship. These are all orders.
Saying what?
Yes, your lordship. It's lordship as per direction of the Honorable High Court dated 5/5/2022, your lordship. So I have been directed to pay an
Deposit.
amount of 1,000, your lordship.
Huh.
And also the impugn order was stayed, your lordship, and accordingly, pursuant to the order dated 5/5/2022, lordship, I have been paying you, lordship. I have just got you, lordship, this, but I have gone through this cursory look just, your lordship.
2025, he has been paying that 1,000.
Yes, your lord. Up to date.
My lord, let us have a copy of this order. And my lord, my instruction, my lord, that he is not getting, my lord, she is not getting maintenance, my lord, as per the order passed by this. Now,
See,
what has happened?
5/5/22, there is an order saying that petitioner is directed to pay 1,000 to the respondent number 2
In the revision application, my lord,
in this revision.
filed by them. Yes.
And the operation of the impugned order shall remain stayed.
My-
So that operation, whatever was granted by that order remains stayed.
Yes.
He only has to pay 1,000 per month.
My lord,
That 1,000 he's paying.
paying from when till when, my lord? That is,
Ah.
my lord. It is
2/6/2022,
Fine,
2/7/2022, 2/8/2022, 2/9/2022.
Even up to lordship 2025,
No.
last part of.
my lord, he is very irregular in payment of my lord. Money.
11/10/2022, deposited 1,000. 5/11/2022, 7/12/2022. Every.
Because the document still speaks of, no, lordship.
She's not withdrawing it is another thing. She
My
must
lord,
withdraw it from the court.
If it is deposited, my lord, of course she will withdraw, my lord, because she is in hardship, my lord. Financial hardship, my lord. Now, my lord, she as well as his son, my lord. 10 years son, my lord.
What do you want from this court?
So, lordship, as of now, lordship, my recent instruction as on lordship today, and some few days ago also, lordship, some development is going on. They're trying to sort out the differences, your lordship. So accordingly, today also I got the information, your lordship, that some time may be needed, your lordship, so that matter could be resolved, your lordship, because already the petitioner entered into second marriage, your lordship. I think the your lordship, the other side also not willing to, it's not possible to.
What was the amount granted by the trial court?
Earlier, your lordship, in the DB case, your lordship, that is on page 11, your lordship, it was directed to pay, your lordship, 1,000 and 2,000, your lordship.
Theek.
As per section, your lordship.
Then what happened?
Lordship may kindly be looked.
Then what happened?
Then what happened, your lordship, being agreed to the impugn order, your lordship. Then
The
they
appellant
an
filed
appeal.
it.
They made an appeal, your lordship. Then it has been order been modified, your lordship. Enhanced up to 3,500 and also a quantum of total amount of 40,000 as a compensation. So against that order, I am before you, lordship.
You are aggrieved by that 40,000 part.
40,000 as well as I am aggrieved by to lordship this is appellate order, your lordship.
But you did not file any appeal against the earlier order.
Page 20, your lordship.
The first order you did not file any appeal. First order you did not file any appeal.
No, lord.
Then
First,
why is that amount not being paid?
No, lordship, they have filed an application, your lordship.
We hold that their appeal was wrong. We set aside that appeal. Then what is your liability? According to the first order.
Yes, your lordship.
What is the first order?
First order is at page 11, your lordship.
The amount.
Yes, your lordship. First order, that is the judgment delivered on 21/2/2019, your lordship. Page 11.
You have paid the compensation of 2,000.
That amount you thereafter, your lordship, when I am before your lordship in the Honorable Gauhati High Court. As per order dated to 2005/2023, your lordship, because I have challenged that order
in the appeal.
Your lordship. I have challenged that, your lordship. Then, your lordship, on 5/5/2022,
Then impugned order was, you set aside your lordship and I have been directed to pay an amount of rupees 1,000 and pursuant to the order of the Honorable Gauhati High Court, your lordship, 5/5/2023, as on date I have been paying your lordship.
What is wrong in this order? What is wrong in this order of the appellate court?
Wrong in this order is, your lordship, on the count that they filed an application, your lordship, under DB Act, your lordship, 12. That right from the very inception of marriage, your lordship. So subjected to physical and mental battering and all. And thereafter, your lordship, 50,000 were demanded. And as per demand of the lordship, as per demand, your lordship, that 50,000 was satisfied, your lordship. Subsequently, again, your lordship, 1 lakh were demanded. That was their allegation. And I totally controverted the allegation brought against me, your lordship. And to that, in order to substantiate my defense, your lordship, I have also introduced 3 witnesses along with my personal evidence, your lordship. So, appellate court, nothing new has been brought, your lordship. Whatever the only reiterated and your lordship reaffirmed only the judgment dated 21/2/2019, your lordship. So nothing new. No. There is no discussion regarding as to what because your lordship, my
Okay, we will do one thing. We will remand this matter back
lordship,
to the appellate court. You file your assets and liabilities, both of you.
Now that is exactly, my lord, I am, my lord, submitting that.
And then let them decide the quantum.
Rajneesh versus Neha, my lord, has been ignored in this case.
It was your appeal.
Correct, my lord. Correct, my lord. But when the quantum of maintenance.
But it is
has
very
to-
fair
has to
on
be
your part to,
decided-
yes.
When the quantum of maintenance is to be decided, my lord, it has to be now, my lord, after 2020. This Rajneesh versus Neha.
So now you file your,
It is him, my lord. He is
both
to
of you will
file.
file, he is here in.
File, my lord. I'll file.
because
Then-
Rajneesh versus Neha, your lordship, both are
required to file. You will also have to say.
But so far he has referred the Rajneesh versus Neha, your lordship. It is not only that the judgment is not only restricted to enhance the amount, your lordship. There are many more things, your lordship. 70 pages judgment, your lordship.
No, I am not saying enhance, my lord. I am
because-
saying that Rajneesh versus Neha has been ignored by the learned trial appellate.
So what do
court as well as, my lord, that.
We'll send the matter back.
That will do, your lordship, as per lordship.
You keep on paying your 1,000.
Lordship.
Send the matter back to the appellate court. Take your affidavits on oath regarding your assets and liabilities and also the other conditions laid down in Rajesh and Rajesh versus Neha. And thereafter come to a conclusion what should be the appropriate thing. We'll give you the liberty to pray for an enhancement of what was given by the trial court. And we'll give him the liberty to pray for a reduction of what has been given by the trial court. Let them decide.
Reduction, my lord, from 1,000. My lord, nowadays, your lordship can consider, my lord, 2 persons.
Heard.
My lord, me as well as my son. 1,000 permanent, my lord. Is it educate, my lord?
So after going through the, your lordship, the revision petition, your lordship, very first day, your lordship.
But I
On
appreciate
5/5/2000, because why this order has been directed to be paid, your lordship, 1,000? Because I was an employee of a pharmacy, your lordship, at that relevant point of time. My salary was only 2,500. Subsequently,
increased.
I left from there.
Subsequently increased. Achha, no, you left job. That is to your peril. You leave your job is to your peril. Yes.
Owner of the pharmacy, my lord. That is what I am told, my lord. He is the owner of the pharmacy.
We'll dispose it off at 2.
Lordship.
At 2 o'clock, we'll dispose it off.
And also one thing may kindly be, your lordship, reflect in the order, your lordship. As per my.
It's coming back at 2.
Lordship, I have the instruction that they are also going to resolve the difference.
No, my lord, there is no, this is, my lord, absolutely, my lord, vague statement, my lord, there is no, I have no instruction with regard to the.
So, lordship, how it
my
will
lord,
be.
settlement and all.
Lordship, how
Your
it will-
lordship has taken a view, my lord.
Lordship, how it will be vague, your lordship, other day 2-3 occasions.
No.
Vehemently objecting
No,
that.
no.
Amount of which 1,000 not been paid, your lordship. So I have submitted all the documents right from the very inception, your lordship. As
This
fact from the order.
court is reminding you, the fight is between the petitioner and the respondent, not be.
26.
Disposal as no. কেটা বাকি কেটা আছে? আচ্ছা, হিয়ারিং আর আছে নাকি? Hearing আগেটা করার। We'll dictate this a little later. Let me finish the other list. Yes. The 48 notice.
I have verified the scanned copy of the record, my lord.
Huh.
This was called for in the earlier bail application.
Huh.
That 48, 47, 36 notice, these are not available in the record, my lord. So, my lord, that we have to call for, my lord. Because that we have to verify whether the notices are actually served or not, my lord.
No, when she was shown arrested,
My lord.
the notice has to be given.
But it is not in the record, my lord. That is why we have to verify.
That is what, when we rejected this petition earlier,
My lord.
when we rejected this petition earlier, this case record was only called for.
My lord.
If there was a 48, 47 or 36 notice, have been there.
Sometime, my lord, it does not, they sometimes they does not send along with the scanned copy of the record, my lord.
Huh?
Sometimes, my lord, they does not send, my lord, because the scanned copy of the record comes, my lord. Sometimes they does not send, my lord. That is why we have to verify, my lord.
But forwarding report and all means sonorous report is there, my lord.
Where is that order showing shown arrest? Do you have that order here with you? Here,
Yes.
where you are shown arrest? Where is it?
Page 23,
My lord, page 23, prayer for sonorous.
When were you arrested in the first case?
In the first case, my lord, I was arrested on
You were already shown arrested in another case, were you not, madam? Huh?
7/8/2024.
7?
You, on that day, in this case, he was arrested, then
See, even when we feel that a certain ground is going in your favor, granting you a bail, you are not able to assist the court.
24.
Huh?
37/2024.
No, then you were arrested after this case.
My lord.
You were arrested on 37/2024 in connection with
Palmurpur PS case number 178/2024.
where do you find it?
Lordship, it is in the this forwarding report, my lord. Pair, lordship, shown arrest pair.
Where is it?
And it is reflected in your lordship.
Where is it? In that sentence that you were arrested earlier in the other case, in this
My lord,
prayer for Sonal.
in this 23, page number 23, from the bottom last paragraph, lordship. Last second, lordship.
Where is that order allowing the shown arrest?
Allowing order, my lord, I don't have, lordship, it is reflected in your lordship order, my lord. In page number 39, paragraph number 4.
Call heard Ms. So-and-so learned counsel appearing for the petitioner. Also the learned APP. The scan copy of the TCR which was available in bail application number 2612 of 2025 has been called and produced. The related APP has submitted that. What do we call for updated cost, updated TCR?
Updated TCR, my lord.
Since, updated TCR since.
Including the, my lord, 47, 48 and 36 notice, my lord. If it is available.
Since a perusal of the notices under section 47 and 48 of the BNSS, comma, if available in the TCR are required to be seen, full stop. Accordingly, call for the updated TCR containing the notices under section 47 and 48 issued to the petitioner upon his being shown arrest in connection with special NDPS case number 15 of 2024 arising out of Gureshwar PS case number 32 of 2024 pending in the court of the special judge Bagsa. Full stop. List again on 7th of April. The Illinois counsel for the petitioner has submitted that in the absence of notices under section 47 48 while being shown arrest has been held to be illegal. Is on the 6th, 7th of April. Yes.
This refers to order hearing, Lordship has already had it. Under the petitioner applied for the post of junior engineering assistant under the Indian Oil Corporation Limited. Thereafter, my lord, he participated in the written test and secured 93 marks. And he applied for the post of OBC non-criminal. And there was one post of OBC non-criminal and other post were unreserved. Now, my lord, after an RTI application, he came to know that the respondent number 5, 1987, he got only 73 and he was selected and appointed. Then, my lord, again the petitioner filed an RTI where a ground of rejection. Then the authorities said that you are overaged by 7 months, 6 days. Thereafter, my lord, I filed this petition wherein the appointment of respondent number 5 has been made to subject to outcome of this petition. Now, my lord, the advertisement itself shows that OBC candidate will get 3 years of age relaxation on account of.
Where is your OBC certificate?
Yes, my lord. Lordship will kindly come to Annexure C. At page 22.
Date of advertisement?
My lord, before my learned friend proceeds any further, instead of wasting your time,
please.
We have been informed there is another candidate who had filed a writ petition, subsequently withdrew, and he has filed afresh. That will have a ramification because this post pertains to OBC candidates. And there are general candidates involved who might be affected. And in the new petition that has been filed, the general category candidates have been made a party. So hearing them might be necessary for
yes,
because that will have a consequence. So that writ petition is not before your lordship today.
Oh, it has not come.
Petition number lordship is 1380/2026.
Where is that advertisement? Just for my information. Where is that advertisement?
Yeah. Lordship will take up item number 27.
Advertisement is this one, page 27.
Yes.
25/9/2021.
And I am aspiring for the post of my lord 202. There all are similar.
But your OBC certificate is of a later date. Your OBC certificate is of a later date. At Annexure C.
No, my lord, it's 11/2/2022. And the advertisement is 25/9/2021.
21. What was the last date for application? 12/10/2021.
Yes, my lord.
Your OBC certificate is of a later date.
It's a letter date, my lord,
Then?
but
We are not supposed to give it along with the application for relaxation of age.
my lord, at the time of.
Certificate issued later,
Yes.
is it going to benefit you?
Understood, my lord.
Oh.
But my lord, they have already accepted my certificate. That is not in this.
So they are saying that you are overaged.
No, overage after giving me age relaxation of OBC. They have given me.
You want that boiler certificate
Yes.
relaxation also?
Yes. That is not in dispute that they have given relaxation of OBC.
But if it comes before this court, you have to satisfy on that line also. If you find a mistake
Yes.
in their condoning your age because of this certificate, in the other case, notice has been issued.
Six notes for selected candidates.
Then we will take it up along with this. Eleven three, 11/4. Huh?
Perhaps your lordship has been apprised of the other.
Uh-huh.
They're just notices of gone so far. Respondents have not appeared. This batch was heard on several occasions. And insofar as the other 5 items are concerned, they are not involved in this. The issue of age relaxation is not at all involved there. But naturally, this matter will take a lot of time. The general candidates would come file their affidavit. At least the other batch of writ petitions, which are
But
challenging.
Learned Senior Counsel has made a submission that any orders passing this writ petition will affect the general category candidates in there.
My court had heard it the last time. What has happened, there's a post for OBC, for which there are 3 aspirants. Now while that was under consideration, whether Mr. Patwari's client would be eligible for an age relaxation or not, my services were terminated. My, as in the petitioner, of course, my friend appears as respondent in Patwari's case, So far as the other 5 are concerned, there is no issue of age relaxation involved there. They were terminated on the ground that there was some manipulation in the marking. And there is one more item where the ground of termination is that the experience certificate was not right. So, these 3 matters will naturally take time because your lordship will visit the issue of age relaxation, whether
you are saying that they will not have any.
They will not have any. No, that's only in respect of one. The other 5, 27 to the other. So those are general category posts. In fact, the discipline is also different.
Then how, sir?
Posts are different. There is no doubt about it. But the issue started from this case. So therefore, that is how originally all the matters were tagged together. Just to,
these matters were not tagged with along with this, but otherwise,
all the matters are tagged together for the simple reason, the item numbers 27.
We have in our hand is item number 27.
Yeah.
Item number 27, we just have to decide whether this candidate is entitled to a relaxation or not. Relaxation of age or not.
We have already considered.
Huh.
We have considered. That is how Mr. Deka's client was terminated. We are saying that he actually should have been entitled to this additional relaxation. So that is how Mr. Deka's client got terminated.
Insofar as Pranav Pathak's case is concerned, because since he's aspiring for the same post, these 3 can be clubbed. Why the remaining 5?
This Rahul Das is challenging Pranav Pathak.
Pranav.
So we have to decide.
That is also challenging.
So we have to see whether if Rahul Das is allowed, Pranav Pathak goes.
Pranav Pathak goes or moves on to general.
Whatever happens there. But Pranav Pathak, to accommodate him, whatever process they adopt is up to them. But if he is entitled according to the merit, he will be done. Then what about the next case? Next case.
Essentially, my lord, 27 and 28 pertain to the same post.
Huh. So why do you say your termination is wrong?
My lord, my term, because I was already working as an
So?
OBC candidate. So thereafter, my lord, no notices were issued to me, and
Not
eventually
necessary.
they said that there was some anomaly during the selection process. We should have given age relaxation to them.
Huh.
Therefore, we are terminating.
So the select list if recast,
Yes.
and then the proper person is being offered appointment by terminating, what is wrong?
My lord, that I'll argue. I'm just saying about the other matters, my lord.
No, other matters we are not taking up now. Fine, we are keeping it on hold.
Yes.
Tell us about you.
Yes. My lord, my ground is, my lord,
Hmm.
first of all, my lord, I had already rendered more than 1 year in service. My probation was over.
True.
And thereafter they terminated me.
Huh.
And while they terminated me, this issue of age relaxation was already pending.
Hmm.
So without waiting for adjudication on this issue of age relaxation, they
Hmm.
terminated me.
Hmm.
That's one aspect of the matter, my lord.
Hmm.
Secondly, my lord, let us assume that Rahul Das has made out a case for age relaxation. My lord, then he proceeds to the next stage, that is SPPT, and then maybe there's a physical round also.
Hmm.
So today we cannot presuppose or presume that even if he's brought into the frame, my lord, he will eventually clear those rounds. My lord.
Hmm.
Now, what they have done is they have terminated me beforehand, and now they want to. So it's more or less like placing the cart before the horse. Because tomorrow, if they don't qualify, my lord, in those 2 rounds, I remain, my lord. And secondly, my lord, since they were considering this, I should have at least been put to a notice so that I could have placed my case for maybe a migration to the general category because I've scored more than the general category. Of course, that stage has not arrived, which is why the general categories appointments have not been challenged till date. My lord.
Hmm.
So on the last.
And what is the third case, which is the second case which is challenging you?
Mr. Gautam's case, who was filed it recently.
The one that is not before your lordship.
The one
That is
not.
challenging your appointment also.
Yes.
No, now they made a larger challenge that either I go or they are accommodated in the general category.
But you are already in the OBC category.
I was already in the OBC.
You are
what has
even
happened?
you were not considered in the general category.
No.
So why are you a party here?
So because
Because they perhaps.
who will come in, all of them will have a say. Now,
Yeah.
what will happen is, what has actually happened, the OBC category candidates have all apparently scored higher than the general category.
Hmm.
So they should have actually been accommodated against the general
Yeah.
category. Perhaps that is
Not
what
not
is the
if they
challenge.
not if they have taken any relaxation. The
That's
moment they
another
take a
point.
relaxation, it
That's
goes.
another
All
point.
those issues will come up in
Ah.
these 3 writ petitions, the one not before your lordship and item number 27 and 28.
Hmm.
So that 27, 28 and the one not before your lordship have to be definitely heard together.
My lord, what I was suggesting.
Ideally, my lord, may I suggest this one?
No, this Rahul Das can be closed on your submission that you are accommodating him, that you have taken back that rejection on the ground of age relaxation, and that he will be accommodated accordingly by subjecting him to further whatever tests and on his being securing merit enough to be considered for the post. That Rahul Das gets closed on that
Besides
line.
that, we will also have, my lord,
Ah.
since now a substantial period of time has passed,
Hmm.
we may also go in for a fresh selection process. Because there was some anomaly in the selection.
When if he had a right to be considered under that selection process which has already culminated, can you now say that because time has gone through in this court, he will lose that opportunity of whatever he had already cleared? He has already cleared to some extent.
In that case, my lord, that similar direction will have to be issued also in the writ petition that is not before your lordship.
And now, no, whatever is before us, without touching those repetitions, can we come to a conclusion? Here is what we are trying to evaluate.
Because the
If
general
this-
category candidates will have to, at
No,
least
if
they have to be given. an
Rahul Das has got nothing to do with the general category candidate.
He might come into the general category, my lord, Rahul Das.
How can he? He is taking the age relaxation. He cannot. We will observe that he cannot be considered as a general category candidate because he has already taken the relaxation and there is no notification from from the respondents to the extent that even if you take a relaxation, you'll still be considered in a general category candidate. Cannot. Jitendra Singh was there, and what was the Eva? Deepa EV.
Yes.
Deepa EV will come in.
All those, because
Deepa EV will come in, therefore he gets a chance for consideration on the later on stages
this
on
is
his
an
merit.
aspect. Let me, Because the other writ petition, we have not even received a notice so far.
Which one? The three of them?
No, no, the one that has been filed afresh,
Huh.
where the general category issue
We are,
has come up.
we are still not going into that. Let us just try to see if we can,
What will be the
if we can,
consequence thereof?
if we can cut, that is what we are trying to see. Now, if Rahul Das gets a consideration according to his merit, this writ petition is not disturbing anybody till now, save and except whether Pranab Pathak is to go. Pranab Pathak's case is I should not have been terminated and I may not have been terminated if he fails in the rest of the selection process. So therefore, if his termination is held to be bad, then he continues till his consideration is complete.
Yes.
Once his selection is complete, he has not filed any petition saying that I should have been considered under the general category candidate. So once he gets terminated because of accommodating him, only then his cause of action will arise.
Yes,
That will be
so-
something later on. And their case as to whether this person should have got the general category benefit or not will be hanging with his new case if filed.
Yes,
Whether he can be
absolutely,
considered as a general
absolutely.
category. I don't see the
What-
connection.
but the connection is, my lord, since it pertains to the same post, ultimately it might so happen that all three of them might be contesting for the same OBC candidate. So what I am saying is, if your lordship.
You are not asking for any OBC reservation or anything. You are also OBC candidate.
In fact, my lord,
Okay.
your lordship may pass that order, what
Huh.
has fallen from your lordship. I am just saying that let there be a common order in Mr. Patwari's case and Mr. Gautam's case.
Why I have reserved?
These two
Otherwise-
are-
otherwise what will
I
happen?
don't see how they are connected.
They are connected because they are contesting for the same post. Now, what might happen is, if your lordship passes this order in Rahul Das's case today, and by chance for technical reasons, the other writ petition which is not before your lordship, it takes about 6 months' time. We will have to keep undertaking the same process for the same post on 2-3 occasions. Instead of multiplying the consideration, it will simplify the whole issue. Immediately on reopening any date, your lordship may fix well, these three.
They would like to have their affidavits, this and that, in
Yes,
the other
but
cases.
It's heard on many occasions, this series.
Your lordship, I'm appearing for Indian Oil on instructions and they can serve the copy.
They'll serve
Take
you.
it right.
What I'm trying.
And how long would you take to file your affidavit? In those cases?
He perhaps need not even file an affidavit because his pleadings are already here. It will be the other general category
General
candidate
candidate.
who will have to file.
Well, what are,
There are two candidates,
there are two candidates.
Jintu Deka and Minal Deka.
Well, once your lordship disposes of Rahul Das's matter, only then things would get clearer. In the sense whether Rahul Das actually occupies the general category, whether me and Mr. Gautam's client have to seek a migration, all that is my lord, on speculation, because it all depends on whether Rahul Das eventually clears the next rounds. My lord. And secondly, my lord, that migration issue that your lordship had also observed on the earlier occasion, once he is accommodated in the OBC category, my case, Mr. Gautam's case, and those general candidates' case can be
You have also taken some
relaxation.
relaxation. You cannot go to the general category. Your candidates?
No,
all taken
he's
relaxation.
taken relaxation, I've not taken.
You have not taken. He has a chance to go to a general category. You cannot.
So therefore,
What certificate? No, the experience certificate, whether you got marks or not, is fine. But it will be only considered in the OBC category. It cannot be considered against the general category. How can it be considered? Huh? Huh. Once he occupies it, you have taken a relaxation. How can you go to any other category? Everything goes. Or unless your certificate gives you more marks than him in the total. Then there's only one post for OBC. You have got no chance. 21st. Okay, we'll take it up on the 21st then, sir.
Yes, ma'am.
21st?
well, the other matters would they remain tagged? Because
Which
they
one?
are, my lord,
No, we will say that this matter, these two matters will take up on the 21st. Since it has been stated that there may be other petitions which may have a bearing on this writ petition. And it will be upon you people to get it listed on the 21st along with these writ petitions, if you can maintain. I cannot pass an order in a writ petition which is not before me.
No, your
Nor-
lordship
I
can
was
simply
just
say,
referring to the other matters, starting from 29 onward.
What is 29 onwards?
Those matters, what has happened, Rahul Das preferred a complaint. My relaxation was not.
What have been listed today will be relisted on 21st.
I'm just saying about the other matters, not relating to this OBC post at all. Those are other matters are 29 to 30.
What is the grievance
The
that?
pure matters of termination, no issue of age relaxation is involved. What they're trying to say is because of this confusion.
Those are not Pranab Pathak, those are some other candidates.
Yes, madam. Other candidates.
same selection process, different posts.
Different posts, different termination.
But the termination is
different
under challenge.
Yes. Only the termination is
And
under
those are not OBC category
No,
candidates.
no,
So,
that-
Can we take them up or sir, we
yes.
keep everything?
Let them come up on 21st. Your lordship may indicate that they will be heard separately. On that day,
We can do that on 21st, all of them. Whatever is easy for disposal on that day, we'll take it up and we'll dispose
yes,
it.
yes.
But that is on the understanding that we'll take up something for disposal on that day, we'll make an attempt.
27, 27.
No deferment on these grounds.
Yes.
We cannot keep it part-heard, we'll have to release everything.
At
Otherwise.
least till 21st.
21st we'll keep it, but
Yes,
after
sir.
that we'll have to release
Yes,
it.
sir.
It'll be a waste of court time otherwise.
In this matter, your lordship may simply say that list along with the connected matter. That will take care of it. Which is not.
No,
before
in
you.
this, heard Mr. So-and-so agro order by Diriba Gutekizana say, Habo, release this matter on the 21st of April, 2026 for further consideration, since it has been stated that there may be other writ petitions and which may be required to be taken into consideration at the final hearing of this case. Which one? No, we are not doing.
This. Your
No,
lordship
we
can say list along with.
But what did I say? There are other writ petitions which may require a consideration, being WPC number. Yes, what are the numbers?
There's just one.
There's just one.
Okay. Require consideration. We'll stop.
But in case this is not taken up, my prayer for detacking of the remaining will be considered.
Mr. Deka, Learned Council is paying for WPC number
1070, 1071, 1075, 1076 and 77.
has submitted that these writ petitions can be heard without reference to WPC number 1373 of 2022
1069
of 2022 and the notun writ petition kan number given, the new writ petition. Okay. The same will be considered on the next date.
Yes.
May I please your lordship? Actually, we fixed the time for Passover, but then my senior had to go to the Judicial Academy for his lecture. So the matter may be fixed for another.
TCR is received. Have you gone through? The TCR has been received. A prayer for accommodation has been made by the Learned Council paying for the petitioner. List again on. When do you want it?
A short date may be given.
8th of April.
8th of April.
May please your lordship. So these are three connected appeals, right? One appearing in item 34, those appearing in 35 and 36. The lordship may remember this case, my lord. We had taken up that plea, my lord, regarding 313 statement, my lord. 313 was not substantially complied with. In so much as, my lord, the evidence of each witness, the entirety of the evidence of each witness was put in the form of one question. PW1 one question, PW2 another question. So your lordship had indicated on the last occasion, this cannot be done. So this question of whether the matter may be remanded back
for remanded back to the extent of the trial court re-recording the statements under 313.
Yes.
And then proceeding with the
What is the
trial.
difficulty, madam?
One thing, my lord, may fairly submit also, because this issue, the law, my lord, is that the lordship will also have to see the extent of prejudice. Only non-compliance per se will not vitiate the trial. The question of prejudice is also there, because if your lordship sets aside this order, this person, because all of them got into custody because of the judgment. So once your lordship sets aside the judgment and remands it back, they will have to be released.
No.
The question of prejudice.
Not necessarily, huh?
Because they were on bail. They were on bail during the entirety of the trial.
We'll allow you to remain on bail till the.
Yes, that can be done. Yes.
We'll allow you to remain on bail
Yes.
as if the statements under 313 had been not recorded by that time.
Right.
After recording a statement, whatever the judgment is, you.
That's
Otherwise, do you have any judgments which you wanted to say? Because you,
yes,
since you are saying that, where is that? Show us.
I'll just three judgments.
What does it say? Allowing you to remain upon remaining bail.
No,
The prejudice part.
The issue of prejudice, my
Ah, give it to us. Lekhak heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. Gotek jana naam to beleg diba, ha? Mr. So-and-so in criminal appeal number so-and-so, Mr. So-and-so in criminal appeal. All your grounds are same, the same ground. Anything, he's still on bail. He was not taken into custody when the judgment was delivered. So only the point of law is same, or is it the same? No, is it the same judgment through which?
For all three of them. Because we were sentenced to 10 years of
And
imprisonment.
your client? Behind bars?
10 bars, my lord.
Only you are outside. He is assisting you. You are with? Okay. Which paragraph do you say?
My lord, first your lordship will say Rajkumar alias Suman, my lord.
Huh?
Paragraph 22, my lord.
Paragraph 22.
2, my lord. The criteria is given, my lord, regarding 313, my lord. Page number 105, my lord. Bottom part, my lord.
And your ground for prejudice is that you could not explain these circumstances
Yes, because
against all the evidence.
because the trial court specifically gave a finding to that effect. What had happened, just giving a brief of the case, my lord. 2 girls, my lord, and 2 boys, they went to a hill together, my lord. Subsequently, an FIR was lodged, alleging that the appellants, my lord, in item number 34 and 35, they had raped one of the girls and beaten up 2 of the boys. And the appellant in item number 36, he had molested the other girl. So that was the allegation. Now, we took a plea from the inception of the trial that these 2 girls and these 2 boys had gone together, and this was a case of moral policing. And on the date immediately after the incident, these 2 boys who were there accompanying the girls, they were tied up in the house of the victims, the 2 victims, and they were made to execute an agreement that they were going to marry the 2 victims. Because it was our contention that whatever relationship had occurred between these 2 boys and these 2 girls, not the appellants. So this point was raised during cross-examination. Initially, during examination in chief, neither the rape victims, sexual assault victims, nor the injured victims disclosed this fact. Even the parents did not disclose this fact. It was during cross-examination, when this point was put to them, then they admitted that yes, indeed, these 2 boys, after the date of the incident, on the next day, they were tied up together. An agreement was executed. Subsequently, this FIR was lodged. Now, this aspect was also proved by us by adducing defense evidence. So victims, both injured and sexual assault victims, admit in their cross-examination. DW also proves it. So when a trial court examines this aspect, the trial court says that you had not raised this point during your 313 examination.
Okay.
Hence the prejudice.
Okay. Heard Mr. So-and-so learned counsel appearing for the appellant, also heard the learned APP, full stop. This criminal appeal assails the judgment and order dated 16/5/2023 convicting the appellants in sessions case number 173 within bracket A of 2014 under sections 341/354/323/376/34 of the IPC by the Court of the Learned Additional Session Judge FTC North Salmara. Full stop. The records available reveal that on the basis of an alleged offense which occurred on 21/7/2013, an FIR was lodged on 23/7/2013. Where is that? Where can we find that FIR?
And in the paper book, madam, page 1.
The contents of the FIR
We'll find the relevant
are
page 4.
are quoted below for a ready reference. The accused, no, the appellants in cause list computer. These are item numbers
34, 35, 36.
Criminal appeal number 294 of 2023, where arrest 32 na
34.
34, madam.
34, huh? The appellant in criminal appeal number 294 of 2023 was arrested on huh, both the how many
14
appellants are there? How many appellants are there? Three.
Yeah, plus before.
All the three appellants thereafter faced trial, and the evidence in the trial commenced from 31/7/2015, and the judgment was delivered on 16/5/2023, whereby the learned trial court
Page 180, madam.
huh?
Page 180, madam, sentence.
Just a minute. All and what did I say? By the judgment dated, whereby all the accused were convicted and for offences punishable under section 341/323/34 of the IPC, comma, the appellant in criminal appeal number 221 of 2023 was also convicted and criminal appeal number 294 of 2023 were also convicted under offences convicted for offences punishable under section 376 and 34, and the appellant in criminal appeal number 261 of 2023 was also convicted for offense punishable under section 354 of the IPC. Full stop. It is the submission at the bar that while the appellant in appeal number 294 of 2023, 221 of 2023 are in custody serving the sentences, the appellant in criminal appeal number 261 of 2023 is on bail. Full stop. Having convicted the appellants as herein before stated, comma, the following punishments, sentences were imposed upon them respectively. Prothomote likhibo, appellant in criminal appeal number 294 of 2023 and appellant in 221 of 2023 were sentenced to undergo rigorous imprisonment for 10 years each and to pay fine of rupees 50,000 the appellant in Criminal Appeal 261 of 2023 was sentenced to undergo rigorous imprisonment for 2 years and pay a fine of 20,000 for commission of offense punishable under section 354. All the three appellants were further sentenced to undergo rigorous imprisonment for 6 months, each for commission of offense punishable under section 323/34, and to undergo rigorous imprisonment for 15 days each for commission of offense punishable under section 341/34 of the IPC. All these sentences were to run concurrently. Full stop. The learned counsel appearing for the appellants has submitted that during the trial proceedings, the trial court had committed a grave error while conducting the examination of the accused under the provisions of section 313 of the CRPC, full stop, by drawing attention to the manner in which the appellants were examined. Where is that?
Page 83 starts.
83.
83.
After the case of the prosecution was closed, comma, the learned counsel have submitted that each of the witnesses, each of the accused, there is a long, each of the accused were confronted with the complete evidence of each of the prosecution witnesses at one go and asked to explain their circumstances. The learned counsel for the appellant has submitted that such is not the procedure. Such is not the procedure for examination of witnesses under the provisions of section 313 of the CRPC, and by putting complete evidences of each of the prosecution witness without breaking them up into separate, what do you call it, instances described by the witnesses, comma, the accused had lost the opportunity to answer or put forth their explanation to the evidence led by the prosecution. Full stop. The learned counsel for the appellants have placed reliance on the judgment of Rajkumar.
First judgment on this long and arduous questions, madam.
Huh?
That would be a division bench judgment of this honorable court, madam. Govind Singhal.
On Govind Singhal versus State of Assam.
And paragraph 42 to 49.
Reported in 2022 2 GLT 790, where, according to the counsel for the appellants, comma, the law was discussed at paragraph
42 to 49, madam.
42 to 49.
The relevant
Full stop.
finding at 49, madam.
For a ready reference, the aforesaid paragraphs are quoted herein below. Full stop. The learned counsel for the appellant has submitted that as per the findings of the division bench of this court, comma, the trial court should avoid posing long and arduous queries to the accused and instead bring to his notice in a concise form only the incriminating evidence available on record against him. This court had also held that the duty of the trial court to put the substance of all the incriminating circumstances to the accused by framing specific and separate questions on each incriminating evidence brought on record against him. The trial court would be under a duty kobo, huh? Upor je likhise, the trial court would be an under a duty kobo, huh? And give an opportunity to the accused to offer explanation. $53 is what would be your relief, is it not? Para 53 is your relief.
Same with this Honorable Supreme Court judgment in.
And that's okay, but otherwise 53 covers the relief that you're praying for now. Para 53. Kindly have para 53. Then what do you have? This nursing, why this?
Para 30.3, my lord. Internal page 510.
Para 30?
0.3, my lord. Summary of the judgment.
The learned counsel for the appellants have also placed reliance on the case of Nursing versus State of Haryana, reported in 2015 1 SCC 496, where at paragraph 30, the apex court had held as follows. This 30.4,
Yes, ma'am.
then we will have to go without the 313 statement.
30, that is, my lord.
30.4, if we have to follow that, we have to go without a reference to the 313 statement. Can it be done? In this case, it cannot be. The learned counsel for the appellants have thereafter placed reliance on the case of Rajkumar alias Suman versus State within bracket NCT of Delhi, reported in 2023 17 SCC 95, to impress upon this court that
Here, my lord, will find the para 22.
That unless the material circumstances on the basis of which the prosecution is seeking a conviction are placed before the accused in form of concise questions, comma, the accused would be prejudiced in placing their defense before the learned trial court. Full stop. The learned counsel for the appellants have argued that it was the specific case of the defense which would be reflected in the cross-examinations conducted on the prosecution witnesses, as also the statements given by the defense witness that there was material irregularity in the evidence led to the extent that a wrong story had been projected in the FIR, and a wrong story was sought to be proved through the charge sheet. Full stop. The learned counsel for the appellants submit that it was the consistent stand of the defense that the petitioners were not involved in the alleged incidents, and rather persons accompanying the alleged victims had taken part in the alleged offense and had also thereafter been detained by the family and co-villagers of the victims. And it was only after an agreement was arrived at between the alleged victims and their actual perpetrators that the FIR had been lodged, implicating the appellants herein of offenses which they did not participate in. Full stop.
Just one correction.
Huh.
Agreement did not specify this part. Agreement specified that the victims will be marrying this.
I simply said that only after reaching an agreement with the perpetrators that the FIR came to be filed. We are not saying what is the agreement about. We will not prejudice you on that. If we say what is the agreement about and all that, you will not be able to
Navigate it out.
navigate in the trial court. No? Full stop. The learned counsel for the petitioner has submitted that when long questions had been put to the accused without specifying the exact evidence which were found to be against them, the accused appellant did not have the opportunity to explain elaborately or to answer each of the evidence specifically. Full stop. The learned counsel for the appellant has submitted that this aspect assumes importance since the defense of the appellants have been rejected by the learned trial court only on the ground that they did not put forth any explanation or any explanation to the questions put to them during their examination under section 313 of the CRPC, and when and that they did not put forth their defense while they were being examined under section 313 of the CRPC. Full stop.
That perhaps you'll also find it, page 160, para 51, specific finding.
The learned counsel for the appellant has referred to paragraph
51, my lord, page
51 of the impugned judgment, which quotes that during the examination of the accused persons under section 313 of the CRPC, when incriminating materials appearing in the evidence were put to them, they simply denied the same. Full stop. Yes, madam, what do you say?
Not yet. That is enough.
Huh? Ms. S.H. Bora, learned APP, appearing in the matter, has submitted that the petitioners had been afforded the opportunity to explain the circumstances which were not found in their favor when they were examined under the provisions of section 313 of the CRPC, and having failed, there is no illegality or irregularity in the order passed by the learned trial court in holding the appellants to be guilty of the offences as reflected in the order dated 16/5/23. Full stop. The learned APP has, however, fairly submitted that the examination under section 313 of the CRPC in the present case seems to be not in accordance with the law laid down by the apex court, in as much as specific questions were not put to the accused personnel, and it is apparent that the entire evidence of each of the PWs had been put to the petitioner in a single paragraph, asking them to explain the circumstances. Full stop. The learned APP has submitted that even in the event it is held that the accused had suffered a prejudice when they did not have a complete opportunity of defense while their statements will be recorded under section 313 of the CRPC, the best relief that the appellants would be entitled to is for a retrial from the stage of recording their evidence, recording their explanation under section 313 of the CRPC. Then you would have the whole defense again.
Yes.
You'll put up your defense again with all the witnesses and everything. Entire cross-examination has to come in again.
No, madam, not the cross-examination of the prosecution witnesses.
Of the defense.
Defense, my lord, perhaps it may not be necessary, but the right would remain, my lord, because case would revert to that stage, my lord.
That stage, yes. Full stop. We have considered the submissions made, and then we have no go. This court has considered the submissions made at the bar, perused the impugned judgment, and has also perused the records made available in the paper book in this set of criminal appeals. Full stop. It is a settled position that is the judgment. when an accused is brought in to offer his explanation to the evidence which stand against him and had been led by the prosecution, the accused has to understand each of the incriminating evidence against him so that he has a fair opportunity to explain the existence of such an evidence, full stop. He should also, the accused would also have the right to explain his stand regarding the evidence led against him, full stop. It is not the case of the state that the questions put to the accused were concise to the extent of placing only the incriminating evidence available against the accused, full stop. A perusal of the recordings of the learned trial court during the recording of the statements under section 313 of the CRPC exhibits that the questions were long, arduous, had contained voluminous details, and were not in the form of interrogatories. Full stop. In the case of Gobind Singh, within bracket Supra, this court had found fault in the manner in which the examination under section 313 of the accused had been done. We have gone through the nature of the questions which were put to the accused in the case of Gobind Singhal within bracket Supra, and we do not find much difference in the manner in which the recording of the statements was done in that case and the manner in which the recording of the statement under section 313 of the CRPC has been done in the present case. Full stop. Since I don't explain next paragraph, since the petitioners have been able, the appellants have been able to exhibit the prejudice caused to them when they could not put forth their explanation during their examination under section 313 of the CRPC, and having gone through the evidence of the prosecution, more specifically the cross-examination and also the evidence of the defense, this court finds that the trial court had indeed committed an error when it observed that the petitioners were unable to explain the circumstances when incriminating materials appearing in the evidence of PW1, PW2, and PW3 were put to them. Full stop. In view of the above finding, this court finds that this is a fit case where the matter has to be remanded back to the learned trial court to conduct a retrial of the case from the stage of recording the statements of the accused so-and-so, 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 under section 313 of the CRPC. Stop. Para 53 para ekhini uthai dibo. As held in the case of Gobind Singhal Supra, this court directs para 53 ma jekhini pencil dag di disu. When was the incident complained of? FIR dated?
FIR dated 23/7/2013.
13. Okay, 2013. Here 17 বুলি এটা আছে, তারপর 13 লিখি দিছো, ঠিক আছে? First up. although keeping in view the long time which has passed in a long time has passed since the date of the alleged incident, and this court this court is of the view that in the absence of the recording of these statements under section 313 of the CRPC correctly and appropriately as required in law, this court would should refrain from passing final orders in the appeal. Full stop. It is in that view of the matter that this court deems it fit to request the learned trial court to take on, has requested the learned trial court to take up the matter on a day-to-day basis if necessary. To bring the trial to its logical conclusion at the earliest. Full stop. The accused number 1 and 2, who have been stated to be in custody on and from 18/5/2023.
Yes, madam. From the date of judgment, madam.
18/5/2023.
2003.
Sentencing.
Yes, ma'am.
From sentencing, they are in.
Yes, madam.
From 18/5/2023, this court deems it fit to direct the learned trial court to allow the appellants the privilege of bail on such terms and conditions as may be necessary to ensure their participation in the trial. Full stop. This privilege of bail is granted on the statement made by the counsel for the appellants that the appellants were allowed to remain on bail till the date of their sentencing. Yes?
Yes, that is there in the judgment also.
No, that is, we are just noting down your this thing. Why we have allowed the bail is what we are trying to justify. Yes, you are saying something, madam? Huh?
Objection may be recorded.
Objection to the bail. Although the learned counsel, although the learned APP, Ms. Bora has objected to the grant of bail, this court is of the opinion that when the petitioners had participated in the trial and had also surrendered for the sentencing and have been carrying out this sentence, they would be entitled to the privilege of bail during the trial proceedings, the retrial proceedings, full stop. It is stated by the learned counsel for the appellant appearing in criminal appeal number last photo, that the appellant has been enjoying the privilege of bail during the period of this appeal also. Full stop. Accordingly, the aforesaid appellant shall be aforesaid appellant, namely Mr. Utpal Rai, at the rate of Utpal Chandra Rai, at the rate of Namal Rai, shall continue to enjoy the privilege of bail till the conclusion of the trial. Criminal appeal. Now, these 3 criminal appeals are accordingly disposed of by this common order.
I'm deeply obliged, madam.
আৰু এটা জাজমেণ্ট দিবলৈ আছে, কোনে ল'ব? এজনে লৈ থাকি লাভ নাই। এতিয়া নেক্সট কি আছে?
Absolutely sorry. I
There's
could
no
not come in the
difficulty, sir.
first up because I was in the midst of an argument. It's
No
just
difficulty.
concluded, but that's why
No difficulty, sir. Which was the item number?
24.
24.
But it will take some time. I don't know how your lordship is placed today. Because this is a
What
for
is that
final
matter?
disposal, but this is a matter of 2015.
What is the matter about?
If your lordship looks into the principle, it's very simple.
Uh-huh.
There cannot be any stagnation in the service career of any employee. Here, the lady is the third.
We have around 2-3 judgments to be typed out today,
That's why I'm told.
and I would not be available from tomorrow.
Yes,
So I don't think we should be dictating more today.
yes, madam. May I pray, my lord? It may be next week on 7th.
At the request of the learned counsel for the petitioner, Mr. B.D. Kumar, learned senior advocate, assisted by. This is matter again on 7th of April.
Yes, lord.
Mr.
Requested by both the parties.
Mr. Deka appears and does not object to the prayer for, to the request for listing it on 7th of April.
Because I am also not seeking time because it's a matter of 2015.
I understand.
That's it. Normally that direction I think is not given top of the list or something.
No.
Obliged.
Some courts do it,
I
but if we start a hearing in the morning, this is what we
But this
particularly
will
feel.
take-
If we
yes,
start
this-
something in the morning, the entire batch has to wait.
Yes, and this will take around 2 hours.
Huh.
We are obliged. Your Honor.
Obliged.
I'm again saying sorry that I could not.
There is no
because
difficulty.
Normally I'm always there, but if hearing there, then it doesn't look nice.
No difficulty at all. No difficulty at all. sir.
Any court.
We try to accommodate as much as possible.
But they are obliged.
Yes, item 40. 40. Oof.
Matter of time paying for adjournment, Lordship. As per the order dated 16/2, there were
16? 2.
2026.
Ah.
There's a chance of settle outside the court, Lordship.
Uh-huh.
But we could not communicate the petitioner, Lordship.
Huh.
It
You didn't inform us on the next date also, 6/3 also.
As a last chance on after Bihu, Lordship.
My lord.
Yes, sir. This is regarding what?
Passing of FIR, Lordship.
What is the FIR about? What is the FIR about? Land.
Then, Lordship, then.
Eh? What kind of a compromise can be entered into? Where is that? Where is that?
The affair is, my lord, in your case at page 92.
94, Lordship.
এটা চলাই দিয়কচোন অকমান গৰম উঠছে ভোঁটো চলাই দিয়ক
Mm,
94 Yes, sir, they are saying some compromise.
My lord.
They are talking about a compromise.
My lord, they are telling.
Maybe they'll give you back your land, they'll compensate you for that, and everybody can be happy without anybody deciding anything.
My lord, what happened, they are taking the time on that ground, that compromise will be done, but never they do it. And this is a case where they, by misleading the honorable court, they have filed this case. The FIR cannot be quashed. I have brought that to judgment of the apex court.
FIRs, if they do not display.
They said that FIR, I have filed a civil suit. But the honor and refer the case of the Phanjilal case, whereas Phanjilal case I have gone through it. Phanjilal case, different case, where the police officer, below the rank of SP, a police officer made the investigation. But here is the case where the deputy commissioner himself, DC crime bench, made the investigation. That cannot be. Secondly, Lordship, their judgment itself.
Forced sale deed. Are you in possession of the land? Has the land come back to you or it is still with them?
The investigation made by higher officer, competent.
The land.
Yes, madam.
Is it with you?
No, it is, he has fraudulently executed the sale deed.
Sold it to someone.
That sale deed was made an inquiry by the DC and found that there is no such sale deed in the office of sale deed. He himself has done it by own stamp and seal. That's why the officers have been put in the jail. Circle officer.
Now, when do you want it?
And this.
When do you want it?
After vacation, Lordship, any date? 21.
21/4, we'll observe in this order that they have stated time and again that there is some compromise going on, which you have objected to, that they are not coming up for a compromise. As a last opportunity, list the matter again on 21st of April. And if no compromise is brought to the notice of this court will go to decide the matter on merits.
Yes, sir. Yes.
Yes, heard Mr. So-and-so learned counsel. Appearing for the petitioner also heard Mr. R.C. Saikia, learned senior counsel, assisted by Ms. M. Sharma, learned counsel for the respondent number 2, Mr. R.J. Burwa, learned APP is present. The learned APP has submitted that the case diary has been received.
Yes.
This criminal petition is assailing an FIR dated 30/11/2023 where
Yes.
specific allegations regarding forgery of a sale deed has been made.
And
Full stop. The learned counsel appearing for the petitioner had on the last two occasions made statements that the matter is on the verge of a compromise with the respondent number 2, and therefore time was sought for. Mr. R.C. Saikyal and its senior counsel has today submitted that no such proposal is forthcoming from the petitioners. Full stop. Accordingly, at the request of the learned counsel for the petitioner, taking note of the above,
Hello.
this court directs the matter to be listed on the 21st of April 2026, on which date the petitioners shall place before this court any compromise which may have taken place between the petitioner and the respondent number 2. It is made clear that in the absence of any such compromise being placed before this court would proceed to decide the criminal petition on merits.
And no further sons will be given to them, further development. Because my lord, what happened? A dead man, how he can execute a shell deed? The mother of the respondent number 2, they have shown that shell deed is executed in prison.
On the lighter side, sir, we have seen dead men executing affidavits.
That is to also false affidavit. How a dead man can come to execute a shell deed?
They might have gone and come back.
From
They might
heaven.
have gone, get this signature and come back.
From the heaven.
There is also another place.
My lord.
Huh?
Homeless lord.
Yes.
Homeless lord.
Yes. 45. Anupama Suri. You lie, PPK. Yes, sir. What is under challenge here?
Chip on day before yesterday, it was heard.
Hmm.
On the ground, the appellate court has interfered the conviction. Now, on that ground, it was sent for retrial.
Huh.
Day before yesterday.
Oh, yes. Can it be done?
My lord, Lordship has put two queries on after me, my lord. The first thing is, what is my lord, because my lord, he was convicted by the trial court, the petitioner, my lord. In appellate court, my lord, set aside the conviction and send back remand to the, my lord, send back remand for retrial, my lord. Not retrial, my lord, but for
Oh, that case where we are saying that whether the prosecution given a fresh chance.
yes, son, my lord.
Hmm.
Now, the second question was that, my lord, so second question is that, my lord, can the trial court, my lord, send it for retrial, my lord? The first question was that, my lord, whether appellate court can, my lord, interfere with the conviction, my lord, because conviction has been set aside.
Huh.
And they are not agreed by the conviction part. They are agreed by the, my lord, it was again sent for, my lord.
Half. If we set aside the order, the whole of the order has to go?
Order, my lord,
Or the whole of the order has
yes,
to
no, my lord, there I have seen, my lord, there are, lordship can, my lord, interfere, my lord. Because, my lord, even the, my lord, they are not agreed by the order setting aside, my lord, judgment setting aside, my lord. Even lordship can, my lord, interfere with that part, my lord, which they have silenced, my lord, or which is the subject matter of this criminal inquiry. Now, second question is that, my lord, whether, my lord, it is a case for retrial or not, my lord. Now, my humble submission, my lord, it is not a case of, because the decision they have cited, my lord, my lord, Nasib Singh and another Pandit Ukha Kole, my lord. These are the cases, my lord, wherein, my lord, the entire matter was sent for retrial, my lord.
Yes.
Retrial, my lord, from afresh, my lord. In this case, my lord, the main, my lord.
So you have to tell us very concisely whether this sending back that power of retrial, when can it be exercised, under what circumstances?
That is, my lord, in, my lord, exceptional circumstances.
So now when the prosecution fails to bring on original documents.
Original documents, my lord.
And the accused has already got a relief based on the lack of evidence at the hands of the prosecution.
My lord.
Would it still be a case which would require a retrial?
That is, my lord, it is not a case of retrial, my lord. Only, my lord, what is the, my lord, the main, my lord, the points which they have silenced, my lord. That is page number 45 of the criminal petition, my lord. It is stated as follows, my lord. The case is remanded back to the learned trial court with a direction to give opportunity to the prosecution to call for the original documents from the Zimadar and to re-examine the PWs, my lord. This is important. Only on the point of documents, my lord. It is not that, my lord, they will call for the entire prosecution witnesses
This
And
was
they-
the only ground on which he set it aside. The
Right.
conviction. That when the original documents are not there, no conviction. Finished.
Yes, my lord.
But somewhere in the mind of this session judge, somewhere in the back of his mind, he was holding the accused guilty.
Guilty, my lord. Because, my lord, why it
कुछ
is,
तो हुआ है.
why it is
And he
guilty, my
wanted
lord,
to
that
find
is-
out what has happened.
That is page number 44, my lord. Because, my lord, it is,
We sitting as a court,
my lord.
revision, appeal, wherever, we may have all the impression that this man is guilty.
My lord.
But then we are bound by some powers. Therefore, it is not a civil dress. We cannot think like a man who's sitting
Oh, my lord.
outside. You have to think within this gown and this coat and this band. And therefore, although we might have an impression that something is wrong, it is not up to us to lead the prosecution to show what could have convicted him. We are here to decide. Was it satisfactory? Was any law broken? We are allowing this as of now.
My humble submission is this, my lord. Since my lord, the documentary evidence, my lord, as whole by the learned appellate court, my lord, the documentary evidence is paramount evidence in a case under section 468, my lord.
And
It's a
that
case of
the-
468, my lord.
Huh.
And documents, my lord, it is not the documents are not available. Documents were very much available. It was seized, it was given in Zimma. But, my lord, during trial, my lord, that was not produced, my lord.
So the persons who were leading the prosecution,
My lord.
be it the person in the court or be it the person who was advising him that these are documents we need to place, they are responsible.
Yes, my lord.
Action would be against them if necessary, but action cannot be against
But that is
the
why, my lord,
conclusion of a
court
trial.
Court allows their appeal, my lord. Court
Because
has allowed their appeal,
another
but-
thing we have noticed is that in the appeal, there is no prayer recorded in the judgment that the prosecution prays for a retrial or being given the opportunity to bring those things on record and therefore it should be remanded back. In the case which we have just disposed of a little bit earlier,
My lord.
the prayer for remand to do it again was there.
Right.
At least a submission that it can be done. Yes, a retrial would suffice the justice. When it was not pressed, when it was not argued, are they not taken aback without notice that it will be remanded back? And the remand back, had it been on a question of law or on a procedure being violated, understood.
Otherwise,
lead
my lord,
evidence.
otherwise the appellate court has the power, my lord, as part of section 386.
Yes, we are not doubting it for a moment.
Only question is that, my lord, appellate
On
court,
these grounds, could it have been?
without, my lord, setting aside the, my lord, conviction, my lord, appellate court should have, my lord, send it for retrial only on the basis of, my lord, this.
That they were convicted on these wrong points. There was a procedural flaw, so we think there should be a retrial.
Retrial.
So we grant them the bail and you do it again. That would have been fine. But when you say that, okay, this document was missing, so the conviction is wrong. Now you bring the document and get them convicted. Can it be? That is the bias, judicial bias.
My lord, I have also found in some of the cases, my lord, wherein it is said, but definitely, obviously, it goes against us, my lord. Even when I'm submitting, my lord, it says, my lord, that even if my lord, it is sent for retrial, my lord, that public prosecutor will have the opportunity to, my lord, develop the case first thing, my lord. Second thing, my lord, there may some witnesses who depose in favor of the, my lord, suppose the informant, accused, my lord. That witness may not be available while the retrial, my lord. So these are the, my lord, some.
This was in one of the cases where we had appeared long ago. Our argument was remanding the matter for a fresh disciplinary proceeding in a force like the CRPF.
My lord.
Now, where do I get my defense from? All persons transferred. Many would go for voluntary retirement after serving 20 years. Many might have expired in different activities. And how am I supposed to find out who was present in that battalion on that day and now where he is posted? How do I bring him back for my defense? So the remand back would be fruitless for me. Similarly, it will be here also what you have said.
Yes,
A person who might have spoken in his favor by this time might have
may not be
become a beloved of God, staying with him upstairs. How can I bring him back? Not possible.
That is why, my lord, Supreme Court, Honorable Apex Court has hold, my lord, that only in the, my lord, some, under some special circumstances or on the rarest of the case, my lord, wherein, my lord, the retrial is, my lord, necessary, my lord.
Now, here the retrial in the case that we have just sent back.
Yes.
That retrial was necessary. 313, without 313,
Without,
one
yeah.
cannot defend himself.
My lord.
That is necessary. Here, such a circumstances that the documents could not be produced despite best efforts due to something. In one of the cases in the High Court itself, we could not produce the documents because of the COVID period. Files were not coming to us. I was for the state. So after the judgment, after everything happened, we filed a review saying that it was COVID. We could not bring the file, but the file says so. Judgment was reviewed. The review was allowed, it was reheard. That is a retrial. On a review by the High Court writ petition, fine. But that circumstance is also not there. Why they could not produce is not there. We'll allow this.
Only this submission may be recorded, my lord.
That it has the power to remand back
There is
for
a
a
power
trial?
to remand, and learned appellate court, my lord, only has used the word only, my lord.
Only. So
on the
therefore,
point
only
of
to that extent it
documentation,
was
we are
remanded.
giving chance to the, my lord, accused to cross-examine the PW.
Heard, Mr.
These are
Weighing us down. Heard, Mr. Jizer Ahmed, learned counsel appearing for the petitioner, also heard, for the petitioner, also heard Mr. MJ Borwa, learned APP, full stop. Mr. So-and-so, you have anything to say, sir? Yeah? They are being acquitted. Fine with you. The Mr. So-and-so appears for the respondent number 2. The genesis of this criminal revision petition lies in the order dated 6/6/2024 passed by the learned Sessions Judge Lakhimpur at Lot Lakhimpur in criminal appeal number 9 within bracket 1 of 2023. Full stop. This criminal appeal arose out of the judgment and order dated 6/2/2023 passed by the learned subdivisional judicial magistrate within bracket S, North Lakhimpur in connection with GR case number 1893 of 2019, convicting the petitioner herein under section 468 of the IPC and sentencing him or her to serve rigorous imprisonment for 3 years and to pay a fine of ₹10,000 only, and in default to undergo simple imprisonment for a further period of 2 months. Full stop. The Joint Director of Health Services, Lakhimpur, had lodged an FIR on 27/7/2019, alleging inter alia that the accused herein had submitted forged documents in the office and therefore an investigation was sought for. When and after the accused had faced a trial, the learned trial court had convicted the accused appellant and had sentenced her as herein before referred to. Full stop. The appellant thereafter had filed the criminal appeal 9 of 2023, wherein the learned appellate court found that in the absence of any documentary evidence by the prosecution at the time of trial, comma, the impugned order of the trial court could not be sustained in law, full stop. For a ready reference, the relevant portion of the judgment and order dated 6/6/2024 is quoted herein below for a ready reference. From this judgment at you'll take from page 43. Huh? Page 43, para 7, 8, 9, 7, 8, and 9. Huh? Good stuff. Having set aside the order passed by the learned trial court, the appellate court remanded the matter to the learned trial court, directing the trial court to give opportunity to the prosecution to call for the original documents from the Zimmadar and to re-examine the prosecution witnesses only in the point of documents and after giving chance to the accused to cross-examine the PWs only on the points of documents and thereafter deliver a judgment in accordance with law. This portion of the judgment and order dated 6/6/2024 is under challenge in this criminal revision petition. By referring to the provisions of, what was it, 384?
386B,
386B of
CRPC.
the CRPC, comma, the learned counsel for the appellant has CRPC objection submitted that the powers of an appellate court to remand back a matter for retrial cannot be questioned.
B1.
386B1, huh? Cannot be questioned, full stop. The learned counsel has submitted that although such powers may be available with an appellate court, comma, remanding a matter back for a retrial cannot be done as a matter of course, and such retrials can be ordered and can be directed only under special and rare circumstances when the appellate court finds that the trial had suffered from some material irregularity or illegality, and the same cannot be done in the event that the prosecution had failed to prove the allegations against the accused, or when, or to allow an opportunity to the prosecution to bring in evidence which was not given during the trial originally, full stop. To buttress his submissions, the learned counsel for the petitioner has placed reliance on this. These are your judgments. On the judgments.
4 judgments are
This what this Pandit Ukhla says. Pandit Ukha Khole.
Lordship, at page 939, Your Lordship.
What does it say?
An order for retrial of a criminal case is made in exceptional cases and not unless the appellate court is satisfied.
Yes, just a minute. You say to buttress his submissions, the learned counsel for the petitioner has placed reliance on the case of Pandit Ukha Kolhe versus State of Maharashtra. You'll find it here, huh? You'll find it here.
A constitution bench.
Reported as 1964 1 SCR 926, where the apex court had observed as follows. Huh? I am marking it with a flag mark. Huh? You'll take from the tick to the tick.
The first line. The next page, 940, produce the proper evidence and
Hmm?
will prove their case, there it is sufficient.
The
Where
first two paragraphs.
Page 939,
Huh.
the second paragraph that starts third line, and 940 till second line, it is sufficient.
To produce the evidence and did not know how to prove their case. That
Yes,
part.
yes.
Okay? I'll mark it in with a red pencil, huh? The two tick marks, huh? The learned counsel for the petitioner has thereafter placed reliance on the case of Muhammad Hussain alias Zulfikar Ali versus State, reported in 2012 9 SCC 408. Yes, which part do you want to see?
Paragraph 41.
Paragraph 41.
41.
Where at paragraph 41, the apex court had observed as follows. Okay? I've again page marking it and also it's ticked up. Are the rest necessary?
Not necessary. Same point, Usha Kohli has been upheld.
Eh?
This other two judgment, the Usha Kohli judgment has been continued.
Judgments
Judgment is followed.
Judgments are read when they are short and concise. Long judgments, you tend to skip the paragraphs. Is it not? So when the law is settled, why should you go for all these? Learned counsel has also placed reliance on other decisions of the apex court and has submitted that the law remains settled, that a retrial cannot be directed to fill up the gaps in the prosecution evidence. Full stop. Mr. M.J. Burwa, Learned Counsel, R.J. Burwa, Learned Counsel, appearing as the APP, has submitted that the power of the appellate court to remand the matter back for a retrial in this particular case had been exercised only to the extent that the prosecution witnesses were allowed to be re-examined on the basis of the original documents which were already made available during the investigation and had been handed over to a Zimadar and were not called in at the time of the trial. Stop. The Learned Counsel for the Learned APP has submitted that no prejudice will be caused to the petitioner hearing in case the original documents are allowed to be called back from the Zimadar, and if the PWs are allowed to be re-examined only to the extent of the documents and to cross-examine them to the extent of the said documents. Full stop. Learned APP has submitted that non-examination or non-production of the original documents and non-examination of the witnesses and allowing them to be cross-examined has led to a irregularity in the prosecution which requires to be corrected by the appellate court. And to that extent, the appellate court has observed that since it was a duty of the prosecution to have called for the witnesses, justice would be imparted only if the documents are allowed to be recalled, prosecution witnesses are allowed to be re-examined and cross-examined. Full stop. He has prayed for a dismissal of the criminal revision petition. Full stop. This court has gone through the judgments relied upon by the Learned Counsel for the petitioner and also the arguments placed before this court by the Learned Counsel, by the Learned APP. Full stop. We have also gone through the trial court, the records of the trial court and the appellate court as placed before this court. The judgment and order is still in this petition, in this criminal revision petition, had held that on the failure of the prosecution to prove the allegations against the accused in a manner known to law had led to his acquittal. Full stop. the judgment of the trial court had been interfered with had been set aside on perusal of the records and the evidence led by the prosecution. Full stop. The learned appellate court had come to a conclusion that the prosecution had failed in their duty to call for appropriate documents and to produce them during the trial to secure a conviction of the accused. Full stop.
Which were available.
Huh?
Which were available. It is not the document.
The learned appellate court had also noted that the documents were in fact available at the time of the investigation and had been handed over to a zimmedar, and therefore the learned appellate court had observed that an opportunity is required to be given to the prosecution to call for the original documents. Full stop. In the opinion of this court, allowing such an opportunity to the prosecution to call for documents which were available but not produced would be giving them an opportunity to make the petitioner hearing face a retrial on the matter. Full stop. A retrial would expose the accused hearing to another round of litigation and would afford the prosecutor the opportunity to rectify the infirmities disclosed in the earlier trial. Full stop. In other words, it would enable the prosecutor to lead evidence which he could have but had not cared to lead. Full stop. We read another sentence here. The Apex Court had observed with appreciation and affirmation that a retrial cannot be ordered on the ground that the prosecution did not produce proper evidence and did not know how to prove their case. Full stop. In the present case, we find that though documents were admittedly available, the same were not produced at the option of the prosecution, and therefore the said lacuna cannot be allowed to be filled up at the stage of appeal by allowing the prosecution to, by directing the trial court to allow the prosecution to call for documents which were not produced and thereafter to re-examine PWs. Full stop. It is not in every case that a chance to the accused to cross-examine the PWs would lead to a sufficient defense to the accused. Full stop. We also, this court also notices that during the appellate proceedings, there was no prayer or submission made on the part of the state that the matter be remanded back and they be given an opportunity to produce the documents. Full stop. In view of what has been observed herein before, this court is of the firm opinion that allowing a retrial, even to the extent of calling for the original documents and re-examining the PWs only to the point of documents, after giving a chance to the accused to cross-examine PWs, would be in the interest of justice, or would carry the law, or would carry would be in the interest of justice. Full stop. Although the learned appellate court had the power to direct for a retrial, comma, the reasons given in the order dated 6/6/2024 in criminal appeal number 9 within bracket 1 of 2023 does not suffice the such a retrial. Full stop. The criminal revision petition is accordingly allowed. The directions of the learned appellate court, that is the Session Judge Lakhimpur, as reflected in the order dated 6/6/2024 at paragraph 11 and 12 of the judge order are interfered with and set aside and quashed, comma. The trial court scan copy original actually. The trial court records received be returned forthwith along with a copy of this order. Criminal revision petition disposed of.
What's up?
26.
Anything more? No costs. This was on that line.
Yes.
Heard Mr. A. Devan Learned Counsel appearing for the petitioner. Also heard your Mr. Sen. Right? BK Sen. Also heard Mr. BK Sen Learned Counsel appearing for the respondent number 2. Sole respondent or respondent number 2? For the sole respondent. This criminal revision petition arises from an order dated 17/3/2022 passed by the Learned Session Judge Nagaon in criminal appeal number 17 within bracket N/2019, by which the order dated 21/2019 passed by the JMFC Nagaon judicial magistrate in DV case number 137 of 2016 had been modified. Full stop. The respondent, no, there are 2 respondents. State of Assam is a respondent. It will respondent number 2 koriba ha upor BK Sen for respondent number 2. The respondent number 2 hearing had as an applicant public petitioner preferred DV case number 137 of 2016 under section 12 of the PWDV Act, Protection of Women from Domestic Violence Act, comma, praying for the following relief. Page 12 what A ready mark kori disu A plus C leke ready mark kole bad ready karo okay likhi diba by an order dated 21/2019, the learned JMFC first class JMFC Nagaon had disposed of the aforesaid DV case by granting a maintenance of ₹1,000 to the respondent number 2 herein and her child under section 20 of the PWDV Act. The respondent
We are appearing as legal aid counsel, my lord. Let me kindly be.
A BK Senje for the respondent number 2 as legal aid counsel. The petitioner herein was also directed to pay a compensation of ₹2,000 to the aggrieved woman under section 22 of the Act. The relief was required to come into force from the date of the final order. The protection sought for by the woman from domestic violence was also allowed. It is the case of the petitioner herein that he was thereafter paying the requisite maintenance to the এইটো নিলিখিব হা মাইকে Mr. Sen, up to 2/2/2026, no, 9/3/2026, these are certified copies. They reflect that the order, that the amount has been deposited. He missed 1 or 2 times, but he deposited 2,000 or 3,000 on the next available date as the maintenance, as it reflects in the order. So we will not go into that part of the order. We'll simply make record his statement. We'll give you the liberty to withdraw that money if it is available with the JMFC. And if that money has not actually been deposited even after the certified copies, you can move appropriate applications by taking into account the production of these certified copies in this court. We are trusting you on this. Yes. The respondent number 2 hearing had thereafter presented a criminal appeal number 17 within bracket N of 2019 before the learned session judge Nogao, praying for an enhancement of the maintenance granted and also for enhancement.
Granted on dated 21/2/2019.
Huh?
Granted on 21/2/2019.
No.
Maintenance as well as compensation.
Enhancement, what was the enhancement that was asked?
Yes.
For
Enhancement
is what you are trying to look into.
3,500.
No, you did not ask 3,500.
3,500 enhancement from
Just 25.
No, it was enhanced. I'm asking what was the enhancement paid for?
paid for, yes.
Hmm.
Then, my lord, that appeal is not.
That was not there.
Appeal kon heৰি কৰা নাই.
It's not been reflected in the amount.
The copy of the appeal has not been annexed by them.
Praying for enhancement of the maintenance and also for
Maintenance as well as compensation.
for enhancement of the maintenance and also for compensation of the rupees 50,000 as allegedly paid by the respondent number 2 during the subsistence of the marriage.
No, my lord.
That is what.
40,000 was the compensation, my lord.
Just a minute.
Which was
Just a minute.
awarded.
We are saying what was prayed for.
50,000.
What did the person pray for? She said he has submitted that since the father of the appellant had earlier paid 50,000, the same may be directed to be paid to the respondent, paid by the respondent, is it not? So they asked for an enhancement and they asked for a compensation of 50,000 instead of that 2,000 which was given to them as.
Correct.
Understand? Yes. By the order dated 17th of March 2022, passed in the criminal appeal number 17 within bracket N of 2019, the learned session judge Nogao had enhanced the maintenance to a sum of rupees 3,500
Correct.
towards maintenance of the appellant and the minor's son. Further, a sum of rupees 40,000 as compensation was found to be just and adequate and proper, and accordingly the same was allowed. Full stop. The learned counsel for the petitioner in this criminal revision petition has submitted that there is no basis for the learned appellate court to have come to a conclusion that the compensation would be fixed at rupees 3,500 per month, and for fixing the compensation at rupees 40,000 per month. Full stop. The learned counsel for the petitioner submits that the learned trial court had learned appellate court had taken it upon had committed an error when it took upon itself to assume the income of the petitioner on the basis that he might have been a daily wage laborer, and having calculated his income under the Minimum Wages Act of 1948, the amount of rupees 3,500 was arrived at, full stop. The learned counsel for the petitioner submitted that though it may be true that there has been inflation, the high rise of price of essential commodities, as well as the upbringing of a minor son by providing him nourishment and education, could have been factors to be taken into consideration. However, without determining the actual income or projected income of the petitioner, the learned appellate court was not correct in enhancing the amount, full stop. It is further submitted by the learned counsel for the petitioner that the amount of rupees 40,000 arrived at as compensation did not have any basis. Full stop. He has accordingly prayed that the appeal be allowed and the original order of the learned trial court be upheld. Full stop. The learned counsel appearing for the respondent number 2 through the legal aid, as a legal aid counsel has submitted that there is no infirmity in the order passed by the learned appellate court while deciding the amount of rupees 3,500 to be paid as compensation cumulatively towards the maintenance of the appellant and their minor son, full stop. The learned counsel has submitted that on today's date, with the price, with the inflation in prices, etc., maintenance at rupees 3,500 is also not sufficient, and as such, the grant of the said maintenance does not deserve any interference of this court. The learned counsel has further submitted that the appellate court had taken into account the circumstances in which the respondent number 2 had to leave the matrimonial home and suffer along with her daughter, who have now become dependents on the father of the respondent number 2, the compensation granted was just, adequate, and proper. He has accordingly prayed for dismissal of this criminal revision petition. This court has observed that this court takes judicial notice of the fact that in the case of Rajneesh versus Neha, reported in, we like the counsels to come prepared. When you are arguing on Rajneesh versus Neha, you are not prepared with it.
In SLP number
SLP number so and so.
2018.
2018. The
Order dated 4/11/2020.
The apex court had directed that the compensation or maintenance to be granted to an aggrieved party has to be done on the basis of the disclosure of the liabilities and assets of each of the parties before the court, full stop. This was a case of maintenance in divorce.
In DV case.
There was also a DV case, yes. We tend to forget. It is also seen that the said observations were made with regard to a DV case. Now, while deciding a case under the PWDV Act, full stop. Relevant portion of the aforesaid judgment is quoted here and below for a ready reference, full stop. This court finds that when the trial court had granted, what was the date of the judgment?
4/11.
2020?
2020.
20, na? That when the trial court had decided the amount of compensation, the aforesaid judgment of Rajneesh versus Neha Supra had not come in, full stop. However, when the criminal appeal was being decided, the said judgment had come into force, full stop. Accordingly, this court is of the opinion that the learned appellate court was required to have taken in evidence the assets and liabilities of each of the parties before coming to a conclusion regarding the amount of maintenance to be determined and also as regards the amount of compensation required to be paid to the aggrieved party, full stop. The learned counsel at the bar have submitted in tandem that the interest of justice would be served in the event the matter is remanded back to the learned appellate court with directions to the respective parties to file their affidavits of assets and liabilities before the learned appellate court, and thereafter to decide the amount of maintenance and compensation to be paid to the aggrieved party, if any. Compensation should be, comma, if any, comma, to be paid to the aggrieved party, full stop. Keeping a note.
On the basis of the statement of assets and liabilities filed by the party.
And thereafter come to a decision is what you have said. The keeping in view the consensus arrived at by the learned counsel appearing for the contesting parties, this court therefore finds it to be in the interest of justice to keep in abeyance the order dated 17/3/2022 for to keep in abeyance the order dated 17/3/2022 passed in criminal appeal number 17N of 2019 for the time being, full stop. The parties are directed to appear before the court of this session judge, before the learned session judge, Nagaon, on
4th of May, my lord.
On 4th of May, 2026. Full stop. Upon the appearance of the parties before the court, the learned session judge Nagaon shall take up the matter and shall proceed in the criminal appeal by requiring the parties to file their affidavits of assets and liabilities. Full stop. On such affidavits being filed and after following the due procedure of law, the learned session judge shall thereafter take a decision on the amount of compensation required to be paid to the aggrieved party oblique respondent number 2 herein, as well as the amount of compensation that may be just, adequate, and proper in the facts and circumstances of the case. Full stop. The order dated 17/3/2022, which is kept in abeyance for the time being till disposal of the criminal appeal number 17 of 2019, shall not in any manner influence the outcome of the criminal appeal number 17 of 2019, and the order dated 17/3/2022 shall merge into the final orders to be now passed by the learned session judge after considering the materials which will be placed by both the parties before the court. Stop. This order shall this order shall not be treated as an shall not be treated to impede in any manner any right of the respondent number 2 to either to pray for an enhancement of the compensation of the maintenance and compensation already granted by the trial court. Full stop. However, any such prayer for enhancement shall be dealt with by the learned session judge if as and when such application is filed. Full stop. This order shall also not impede any defense that may be taken up by the petitioner herein to resist any claim for enhancement. Full stop. Do we need to say anything more?
My lord,
The petitioner in the meantime shall continue to pay the maintenance of rupees 1,000 as determined by the learned trial court to the respondent number 2. In case there is any enhancement, comma, the same shall prevail over the judgment, shall prevail over the orders passed by the learned trial court. Have you paid the compensation amount of 2,000?
2,000, your lordship. So far
The petitioner shall also pay the amount of the compensation of rupees 2,000 ordered by the trial court, if not already paid.
So 2,000 is, lordship, only after coming to the High Court, your lordship, for direction, 1,000 being paid.
No, there were two orders.
Yes, sir.
One was 1,000 per month and 2,000 was to be paid as a compensation. We are directing you to pay if not already paid. The respondent number 2 shall be at liberty to withdraw the amounts which have, the maintenance which has already been stated to have, which is stated to have been already been paid by the petitioner hearing before the learned trial court. In case such maintenance has not been paid, the petitioner shall clear all arrear dues before his appeal is taken up for consideration. Before the criminal appeal is taken up for, before his defense in the criminal appeal is taken up for consideration. You first clear all the dues.
my lord, the learned appellate court will be taken, my lord, to dispose
The
matter.
original order of maintenance and compensation had been passed in the year 2000. When? 2000?
Lordship,
Just a minute. We are dictating something. Don't break the line of thought. Give us 1 minute. In 2019.
19.
In such circumstances, it is expected that the court, now considering the maintenance and compensation, would take it up in the correct zeal and have the same disposed of within a period of 3 months from the date of appearance of the parties before the court.
Correct.
Lordship, I have two prayers, your lordship. Kindly be considered, your lordship, if your lordship deems fit and proper, your lordship. One is, your lordship, so petitioner may be allowed to file appropriate petition for reduction of the, your lordship.
That you can
That
do.
one, and your lordship, so far the area part is concerned, your lordship, because as per the direction of the Honorable Gauhati High Court, your lordship, right from the very inception, he has been paying 1,000 rupees. So area amount is it's a heavy amount, your lordship.
Which area amount?
Lordship.
Lordship has indicated if not paid, my lord, it's clear, my lord.
See, you
Everything
have
is
said,
clear.
you have given us certified copies from 2022.
That amount already been paid.
So you did not pay from 19 to 22. You pay it up.
That is what
Only thereafter your case, your defense will be taken up. Not before that. You pay up whatever was in the trial court. You never challenged the trial court.
That was not.
হেতুত অকমান আপুনি bold কৰি থৈ দিব এই মই য'ত লিখিছো যে his defense will be taken up only after payment of the arrears, সেইটো sentence মই correct কৰিব লাগিব. Unless you pay up the entire arrear amount from 19 to 22 if not paid, your defense will not be taken into account. There will be no defense for you. 1,000 a month, a wife and a child.
1,000 has been paying.
Wife, to God, to contract, whatever be the religion, somewhere you say, I will take care of you till I die. And just because a procedure of law is there that you can leave them aside, you will not even pay the maintenance, which you have not challenged. So appear on the 4th of May. Pray for enhancement.